My Lord, I'm going to, I have until 11 o'clock today, so I'm going to focus my submissions on penalty. Before I do that, I'm going to very briefly deal with economic value so far as the points are specific to Intas. I'm not going to repeat anything Ms. Ford has covered. The Tribunal's conclusions concerning the Intas period, so far as they can be identified on economic value, are at the judgment, paragraph 342, page 462 of the core bundle. Subparagraph 4, which you've seen before, and of course it's 6 lines down, the reference to phase 5, which is the Intas period, and you've seen those conclusions before, and there's no wider consideration of economic value, as you've heard from Ms. Ford. Now, I just make 2 points. The first is, once it's accepted that there's no finding in this judgment of an assured customer base, corollary of that is that customers could freely choose full or skinny products at any time. So the question then arises as to what value they attached to Accord UK's products, given their higher prices. The fact that they chose to remain is the first point of significance in itself. We direct you in that regard to paragraphs 22 to 24 of our supplementary skeleton argument, which addresses this court's decision in the Patterell. I won't repeat what we set out there. And as to distinctive economic value over and above that identified by Ms. Ford generally, so far as Intas is concerned...
Sorry, is the point that because prices were declining at some stage, you say there would have been a point at which you do have something which approximates to a workably competitive market, and at that stage, as in the Patterell, you are doing a comparison of what consumers value in terms of comparing A as against B,
Yes.
And that enables you to identify evidence which might be relevant to value. I mean,
yeah, it might be relevant, and the fact that they are choosing to remain is indicative of the fact...
Yes, so the fact that, that's right, as in the Patterell, when a fairly static group of customers decided not to change, but the tribunal decided there was sufficient evidence of switchability,
Yes.
that there was some value being appreciated by the non-switchers.
Yes.
So that's the point. And so in 3424, when the CAT says it doesn't change the position, you say, well, that's just too bland, too simplistic. It doesn't address, the CAT had come to a different conclusion had it properly addressed it. It just didn't address it.
We don't know if they don't address it, and in particular, they don't address the significance of the fact that they haven't found an assured customer base in that regard.
It flows from that.
Yeah.
Well, it's a follow-on from the same point.
Follows on from the same point.
Same
It
point
runs through it. That, yes, I laid the ground for that yesterday, but it's another consequence of that. It's not only for dominance, it's not only for the imposing point, it's also for this point. It runs right through it as a major gap, we say, at the core of the judgment so far as it concerns Intas. And the other point to which we drew attention, and this is in our main skeleton argument at paragraph 33.6, was the evidence given by Dr. Burt that is set out in our skeleton in full at paragraph 33.6. I won't take time over it now, but those were the sources of economic value specific to Intas that Dr. Burt identified. And the CMA chose not to cross-examine any of that evidence, or indeed Dr. Burt at all. Now the CMA says, well, that's incapable. The factors identified by Dr. Burt are incapable of justifying these prices or amounting or demonstrating any economic value. But with respect, that was a matter on appeal for the tribunal to consider. We know that was the CMA's view of the matter. We don't know what the tribunal made of any of that. So I rely on all of our written submissions, in particular in paragraph 33 as a whole. There's 9 points. I won't take time now simply going through them orally. So those are our...
Can I ask you just a point of principle? It's as much, I think, the US for Ms. Ford. In the main, subject to the definition of product market, the CAT endorsed the CMA decision. So the CMA have advanced various points by way of additional justification referring to the decision. it may be open for debate whether that is a respondent's notice point or if in fact the CMA's reasoning was, as it were, endorsed by the CAT and can be, in a sense, assumed by cross-reference. If we find or conclude that a portion of the CAT judgment is defective in some way, but it endorses the CMA decision and the decision then addresses something, what is the correct analysis in those circumstances? Do we assume that by endorsing the decision, the CAT has inferentially, if not expressly, brought into its own conclusions the CMA reasoning? Not certain we've had to address this.
To the extent, not on a general level, no, because there's no general endorsement of their conclusions. In fact, they disagree on market definition, on dominance. They throw out the CMA's analysis and adopt their own analysis, which relies principally on market shares only on a phase basis. And they're obviously on abuse. Their analysis is their three-case structure, which again is very different from the CMA's. So it's very dangerous to sort of extract then something from the decision, which was, after all, under appeal, and which, particularly on points which were challenged but not dealt with by the judgment. It's not an adequate response to our appeal to say, well, we endorse the decision generally. We're left just not knowing what is left standing, and to the extent that our points have not been dealt with, because that's our points criticising the original decision, have not been dealt with because the CAT has preferred its own analysis and its own structure. The only thing remaining would be for this, on the hypothesis that my Lord identifies, would be to remit this matter to a fresh tribunal to look at it again.
I understand the point you're making about the facts of this case, but as an abstract proposition, because as we've had this on a number of occasions, an appeal to the CAT is not a de novo hearing. It is a merit determination of whether the decision was correct, and it can involve new evidence. If at the end of the day the decision or a part of it is upheld on an appeal here, in the abstract, do we assume that the CAT has endorsed the reasoning in the decision?
Subject to any contrary indication in their own reasoning, yes. I mean, typically you would have to set out all the reasons underlying this. Again, so subject to contrary indication.
So there may be many reasons you say in this case where we can't do that.
Yeah.
But at the most basic level of principle, if something's endorsed, it endorses the conclusion and the reasons,
you have to,
subject to whatever the CAT.
You have to assume it's because of those reasons, unless there's contrary indication. Whether you then, what happens as a result of that, if you find something defective in the tribunal's reasoning, isn't to say, well, we restore the decision, because that all depends upon how adequately that tribunal have actually dealt with the grounds of appeal against that decision. Appellants have to have their right of appeal and understand why their criticisms of that decision and the reasons for it have been accepted or rejected.
Thank you.
In relation to dominance, and specifically, the CAT actually went out of its way to say we're not disagreeing with the CMA.
And not disagree with the conclusion, not with the conclusion, no.
Well, nor, it went further than it disagreed with the approach it took, but actually didn't, I think it said in terms that it was, I don't think it was endorsing it, but it certainly wasn't disagreeing. It found no error of principle, or error of law in the CMA's approach, or in the CMA's decision on dominance. It was just the approach that's different.
Well, it found it should have done it on a phased basis, and so it did do it on a phased basis. But then it adopted, we looked at yesterday, its own analysis of dominance on the basis of that. It didn't simply adopt the CMA's own reasons for finding dominance. It focused on market share and that one other point about those without a full MA marketing authorization, full labour marketing authorization, obviously would sell less and so forth, but it didn't adopt the whole structure of the assured customer base and so forth. There's no implicit endorsement of it. Well, I need to move to penalty, and if I may, I'm going to deal with my grounds 3 and 4 together. Can I go to the penalty section of the CMA decision, which begins in core bundle, page 1616. That's where you find the start of chapter 10, which deals with penalty. And at 1618, at 10.12, under legal framework, you can see the self-direction there. The CMA can impose a penalty if it's satisfied that the infringements have been committed intentionally or negligently. The CMA is not obliged to specify whether it considers the infringement to be intentional or negligent. It can hedge its bets, if you like. And the conclusion on the preceding page is exactly that, 10.8. So that's page 1617. 10.8. CMA finds infringements were committed intentionally or, at the very least, negligently. So that was the conclusion on that. And it's reached, as we can see from page 1621, at the undertaking level, so independently of individual periods of ownership, rejecting a submission that this should be broken down into separate periods. See 10.22a. I won't go through all that now, but that's the rejection of that submission, saying no, we're going to look at it as a whole. And the conclusion over the page, 10.23. So when it says Auden actavis there, it's referring to the whole undertaking, knew or should have known that its conduct was exploitative. So it finds that Auden actavis committed the unfair pricing abuses intentionally, or at the very least, negligently, before breaking that down both into knowing or should have known that it was dominant, and knowing or should have known that its prices were unfair. So it maintained the position that there was jurisdiction to impose a penalty. That threshold of at least negligence was passed. The calculation of the penalties which it chose to impose begins in substance on page 1672. That's section D of this chapter, headed Penalty Calculations, by reference to its 6-step penalty guidance, which I take it that the court is familiar with. If you'll note, you'll find it at the Authorities Bundle 2462. No need to turn it up now. We'll stick with step 1, which concerns the assessment of the level of seriousness of the infringement, measured by a percentage, maximum 30%, of relevant turnover. So there's the identification of the levels of relevant turnover, and then at page 1027, sorry, 1675. Sorry, I was looking at the internal one now, sorry. 1675, sorry. Assessment of seriousness, noting at 10.171 there, maximum starting point of 30% is what is applied here for each of the penalties. So they apply the maximum, and that takes into account the nature, looking at the beginning of 10.171, the nature of the infringements, the specific circumstances of the case, and the need for general deterrence. That's what goes in to arriving at that 30% figure. But again, this is at the level of the undertaking as a whole. Paragraph 10.172, further down the page, the CMA focused on the nature of the abuse and the fact that the NHS was obliged to fund drugs which were prescribed. Then over the page at 1676, there we are, 16, no, go, top of the page please, 1676. At C, we can see on this compendious undertaking approach, structure of the market, reliance for this seriousness conclusion on the fact that Auden actavis was the sole supplier during the majority of the infringements, so that's the first 7 to 8 years, and retained a significant market share even after independent entry. Position as sole supplier allowed Auden actavis to increase and maintain prices to very high levels. Reliance further on down that paragraph, 6 lines up from the bottom, on the agreements, having the object of delaying the emergence of effective competition, and the fact in the last couple of lines there was no effective competitive pressure to bring hydrocortisone tablet prices down to competitive levels. So no focus at this point on the Intas period separately, in which none of those factors would apply. And harm to end consumers, again, you can see in the second line there, again, mention of it being sustained by the agreements. All of this going into the assessment of seriousness.
That's all focusing on the Chapter 2 prohibition.
On the Chapter 2 prohibition, this is all, yes, this is specifically on the abuse for which Intas is responsible. The agreements abuses were also subject to a separate analysis, which obviously I'm not concerned with. And you can see at the bottom of page 1676, reference in the assessment of seriousness to the amount of spend. Previously it was £500,000 in 2007. By contrast, during the period in which hydrocortisone tablets were supplied by Auden Actavis, peaked 7.8 million, 84 million in 2016, 62 in 17, approaching 40 million in 2018, and then down. So that is all set out, but including obviously the peak. And then general deterrence is dealt with. And over the page at 1678, it's important to note that all of the foregoing factors taken in the round inform the CMA's assessment of the harm to competition in the specific circumstances of this case. So it's all baked in. Now, at this point in stage one, we made the following point. Firstly, as is abundantly clear, there's no specific consideration of the relative level of seriousness of conduct during the Intas period. That could have been done. We don't say it had to be done at this stage. It could have been done at a later stage. I'll come on to stage 3, which is where you get consideration of mitigating circumstances. But our point was it needed to be done somewhere. In the CMA decision, clearly not here. Page 1682.
All of this assumes there was dominance and abuse during the Intas period.
It does, yes. So all of my submissions on penalty assume that, yes. It assumes that there's something standing at the rest of this which amounts to a lawful conclusion of abuse of dominance by Intas.
Yeah, so if you bring on your first point, this becomes, then we've got to work out how we adjust.
Yes, absolutely. If I'm wrong on my submissions on dominance, wrong on my submissions on abuse, and then the question of penalty is live before my lords, then these submissions bite. Yeah.
Just so we have it, and I'm not indicating any view either way, just take us at some stage through what the analysis becomes if you're right on stage 1. What does that mean for penalties generally?
Right, I will do that, yes. Thank you. Can I just take you through the rest of the decision so you can see how it pans out? On page 1682, you have the conclusion on step 1, 10.185, and then step 2, which is the adjustment for duration. Now, we have no particular difficulty with what the CMA does here at 10.187A. They note that the abuse with which I'm concerned, that's at A, lasted effectively for 10 years. So a duration multiplier of 10 is therefore applicable. But of course, what that means is that that seriousness is multiplied by 10 and it extends right across the full 10-year period. So again, full weight given to years 9 and 10, effectively, or the last 18 months. So then up to stage 3, step 3, which begins at page 1684. So step 3, adjustment for aggravating and mitigating factors. The court from its parallel with obviously sentencing guidelines, which apply in the criminal sphere, the starting point and then adjustment for aggravating and mitigating factors. It's a similar structure. So step 3, assuming that starting point is identified in step 1, aggravating factors, the sole one identified was involvement of directors or senior management. That led to an uplift of 15% being applied, and that's at 1687. You see that conclusion at paragraph 10.198, which unsurprisingly perhaps found that for pricing decisions of this nature were taken at a senior level, is essentially the point. Then mitigating features from page 1694. And Intas was awarded a 5% mitigating discount on the basis of various compliance activities. You can see that the nature of those, 1695. the court will be familiar with the sort of thing, that the fact that staff were trained on competition law and targeted training, that sort of thing. 5% off for that. And then other mitigating factors are dealt with at the bottom of page 1701. Firstly, there was a submission that, well, we've cooperated fully with the investigation. That can sometimes earn a discount. That was rejected on the basis that you need something more than the ordinary. But then the real meat of it is just dealt with in a single paragraph at page 1703. At 10.247 there, Intas argued that prices falling during its period of ownership should act as a mitigating factor. That's a short summary of our point, but CMA doesn't accept this representation. The infringement is assessed as a whole rather than by ownership period, and the prices remained at a level found to be excessive and unfair. The falling prices during the Intas period followed sustained growth in prices for several years, which Accord UK benefited from.
What's wrong with that on the hypothesis that during the Intas period there was dominance and abuse?
What is wrong with that is that the refusal to accept that there is any distinction at all in terms of seriousness or mitigation between the conduct of those who put the prices up in the first place, including under monopoly conditions in the absence of any competition at all, and who maintained it, as was taken into account for these purposes by unlawful agreements, and the conduct during the last 18 months where the understanding was there was market entry, there was competition, prices were inexorably falling and prices were coming down. If, contrary to Intas's belief, that does amount to abuse, that must amount to some mitigation, that your conduct is dropping prices, albeit on this hypothesis not quickly enough, rather than putting them up.
What is incorrect in the last 5 lines, in which there are 2 propositions of fact? The prices remained at a level found to be excessive and unfair, which on this hypothesis they did. And there were falling prices, but they followed sustained growth, from which Accord, the undertaking, benefited. Both of those are correct on this hypothesis, aren't they?
The facts are correct. What is absent is acknowledgement is that there is a qualitative difference between raising prices in the first place, mostly under monopoly conditions, and secondly, believing and allowing prices to come down in response to competitive pressure was acceptable. Now, if I'm wrong
Maybe
about...
said that's inferential within particularly the last sentence. It says you look at everything in the round over the entire period. There were falling prices.
Yeah.
They were still generating abusive profits, albeit less. I think that's inferred but not express. And the undertaking benefited. I mean, it may be slightly condensed, but I'm wondering on this hypothesis, what's wrong with that?
Well,
I understand this is
the facts are correct. What is wrong is that the decision as a whole treats the conduct during Intas's ownership period as every bit as serious as all the conduct which preceded it.
I wonder if that's necessarily correct. I mean, there's an acceptance the prices were coming down, but on this hypothesis they remained abusive. And the prices were falling, but they followed sustained growth, and Accord of the undertaking benefited overall. How different is that from a recognition that prices were coming down and Accord obviously was instrumental in bringing those or following prices down, albeit that had a buffer zone above the new entrant price?
Well, it's different in terms of culpability. On any assessment of seriousness of offending, when you acquire a business because it must be divested following a merger, you take the business on, you look at it, you see that there's market entry, there's 4, then 6, then 7 other competitors, you're putting your prices down repeatedly under pressure of that competition, and then someone tells you later, well, wasn't putting them down fast enough. You should have put them down faster. Now, that is qualitatively different, we say, in terms of seriousness of conduct and blameworthiness than putting them up under monopoly conditions, knowing that you have no competition, you're unconstrained, and can put them up as much as you like. That's the allegation for the first 7 or 8 years of the infringement period. And you saw when I took you to stage 1 and the assessment of seriousness at 30%, that depended upon that conduct expressly and included that. And we say, well, somewhere you've got to acknowledge that that's not what Intas did, and that there is a difference in nature between Intas's conduct and that which preceded it. And that ought to be reflected.
Between two different types of abusive conduct.
Two different, yeah, it's still on this premise, it's still abusive, we get to this stage, but that is, as a matter of seriousness, qualitatively different. There ought to be some recognition of that somewhere. But no discount at all allowed for that. But then it gets worse for Intas. At stage 4 of the page, 1704, is the adjustment for specific deterrence and proportionality, with the first 2 paragraphs on that page setting out the approach. And the approach at this stage is individual, as you see there, to each ownership period. And 1706, paragraph 10.259 and the table below, is the apportionment of the overall penalty which has been reached. So just at 10.258 at this point, just slightly higher up the page please, at this point the overall penalty that they've got to is 56 million odd. So that's total in respect to this whole abuse across the whole period. And they then apportion that, we can go down to the table, between 4 different periods, of which the Intas period is period A4. So it comes out, that's just divided according to duration. So again, the seriousness is spread right across equally, but just split according to duration. And that comes out to just under £8.9 million penalty for Intas at this point in the analysis. But then, in terms of the specific deterrence and proportionality, the first increase upwards is to reflect the amount of financial benefit that Intas actually was judged to have gained. So the table on the next page, period A4 at the bottom, 8.9 million is the step 3 penalty. 12.5 million is in the column entitled Revenue Differential Above £20 per pack Minimum Financial Benefit. And it's that 12.5 million minimum, because obviously they didn't investigate below £20 a pack, that is then effectively relied upon. The further upwards adjustment, though, is born of the size and financial position of each of the ownership undertakings. And at 10.265, see, the penalty should reflect the nature and impact infringement. So the penalties at the end of step 3 do not reflect the serious nature and severe impact. So that is all set out again with reference to the whole period, culminating at 10.268. Again, a sustained period of time, for the majority of which it was the sole supplier. So again, weight being put on the fact that it's the sole supplier, not applicable to Intas. Then the size and financial position is dealt with. At 1712, page 1712, you get the Intas period at the foot of the page. Just slightly further up, please. I think on the heading there, further factors relating to period A4. The reference 2 lines down in that paragraph to period A2, I think, must have meant to be a reference to period A4. And then consideration of Intas's size there and over the page at 10.280, and turnover outside the relevant market at 10.281. So Intas is a big company. 10.282, another relevant factor, was that CMA had written to Intas about the investigation prior to the acquisition to let it know about the fact that there was an investigation at that stage into the undertaking's earlier conduct. Obviously that doesn't and couldn't have covered subsequent conduct from January 2017, but the reliance on that. And then at 10.290, an uplift of a whopping 400%, or a multiplier of 5 in other words, so uplift of 400% from the 8.9 million figure to the end result, further down on the next page, of 44.4 million, and that being assessed by reference to the size of Intas's annual worldwide turnover, annual profit, annual average profit, and sum of its net assets, all of that being considered there for what that represents. And for the final position, page 1746, the foot of the page, the table, table please, the final penalties imposed. You can see now Intas at the top of the tree with its £44 million penalty, representing a percentage of worldwide turnover, 2.7% of its worldwide turnover, considerably in excess of the other periods. And see our skeleton argument at paragraph 47 for various other metrics when compared with other ownership undertakings.
Mr. Farmer, the fact that the 10414 Intas, Accord and Accord UK jointly and severally. I mean, that obviously means as a matter of legal analysis that Intas is liable for 44 million, but presumably it's entitled to recover.
But Intas at this point is the owner.
That, or proportion of that from Accord and Accord UK, is it?
We're in its ownership at this point. What it is entitled to recover is the penalties imposed on Accord UK in relation to earlier periods, because it was indemnified against the penalties in respect of earlier periods upon acquisition. In respect of the Intas period, obviously Intas acquired Accord, and Accord's subsidiary was Accord UK, so they're all within the Intas undertaking for this purpose. This is all in respect to the Intas period specifically, this penalty. And you can see that represents 2.7%, much in excess. And we just simply don't understand why we've ended up at the top of the tree and nowhere has our relative culpability been assessed or made any difference whatsoever.
This is the difference between the concept of an undertaking and legal personality, isn't it? When you impose a penalty, you look at the undertaking, and such changes in ownership, changes in shape of the organisation are largely irrelevant. You have an undertaking. We had this in the BMW case a couple of years ago. When you're trying to attribute individual liability, and you're looking much more on an English company law point of view, it becomes complicated because you're superimposing that on the European concept of undertaking, but we're doing that for, if you like, recoverability, liability purposes under domestic law. And to ensure fairness between respective owners.
But more than that, you're then looking at the identity of the respective owner, Intas here. You're looking at its size and saying, oh, it's a big company, so we're going to up this a lot, so it really hurts a big company. And we understand that in principle, but why should it then also merit a higher percentage of worldwide turnover, or the various other metrics that we cover in paragraph 47 in terms of net profits? It's a whopping proportion of annual net profits and so forth. We settled that out at 47. And there's no answer produced to that by the CMA in its skeleton argument. I must rush to finish it within my time. Can I just make the following further points, because that was the original decision. Obviously, Intas appealed, You will find our written submissions against all of this, which I needn't go through in any way, but you'll find them in the core supplementary bundle, pages 298 to 309, where we disputed that our conduct had been intentional or even negligent during the Intas period. And then the appeal against the calculation of penalty or submissions at pages 310 to 331. So 20 pages just on the calculation, explaining why we differed from this structured analysis conducted by the CMA. And what should have been done, we said, if we were liable otherwise, was a very substantial reduction in penalty, at most at or around the level of the financial benefit of 12.5 million. Indeed, the CMA's first draft penalty statement had proposed to apply an uplift not of 400%, but of 150% as an effective deterrent. The reference for that is a supplementary bundle, page 1852, paragraph 87. It's entirely unclear what changed in the CMA's rationale. Now, the tribunal's judgment, they approached the matter in their decision, judgment paragraph.
I know you want to rush to finish, but just looking at this table for a moment. I mean, it's really that worldwide turnover is significant, isn't it? Percentage of turnover. I mean, the real complaint is that the 2.7% is illogical if the 1.7% for the earlier period is sustained. Then the question is, well, why is Intas got 1% more?
Why have we been promoted to the top?
Over that period. I mean, in fact, the reality is, isn't it, that the earlier period, because it relates to the 10 mg agreement as well, is actually 56,700,000 or whatever. Is that how that's part of the 112?
Well, yeah, it's split up between the different, the different.
So if you look at the total penalty for the earlier period, including the period of the agreements, it's actually going to be 3.4% of the turnover.
But specifically on the, because we're not concerned at all with those
no,
other.
I understand you're not concerned.
Specifically on the 10 meg unfair pricing, the comparison really is with the 1.7%.
Yeah. Yeah, sorry, I took you guys at yours.
So on the judgment, the tribunal dealt with our penalty appeal, all the appellants' penalty appeals, at paragraphs 374. That's page 471 of the core bundle. So having set out the background in the earlier paragraphs of the submissions very briefly, one single paragraph, they then say we adopt a broad brush approach and ask ourselves whether the CMA's approach is defensible. And then that assessment happens over two paragraphs, 375 and 376. And all they say is that taking the case as a whole, we see nothing in the CMA's approach amounting to a material error. No distinction between any of the appellants, no consideration of the Intas period, no consideration of the proportionality of the uplift applied to Intas or its promotion to the top of the league table in terms of percentage of worldwide turnover, or any other metric. And at 376, three material additional points. First one, they now say that these infringements were entered into intentionally and not negligently. Now, the CMA had not contended for that, either in the decision or on appeal. That was at no point put. And there was no cross-examination of our witness who turned up to say it hadn't been intentional on behalf of Accord UK during the Intas period. And yet they made that finding to support the justification for the seriousness of the fine. He said that's wholly unfair. That's our ground 3. See our written submissions on that in our main and supplementary skeleton arguments. Secondly, judgment 376, subparagraph 2. No allowance of any kind for whether there's any lack of clarity for Intas in its position, entering when competition had been established and prices and volumes were now dropping. So unless my submissions on my grounds 1 and 2 are thought by this court to be completely hopeless, we say that simply isn't right. And at 3, the CMA's monolithic approach doesn't require any reviewing at all. We would have preferred it otherwise, but again, there's no effectively uphold the approach of not looking at the seriousness or the mitigation of Intas in respect of Intas's conduct and Accord UK during that ownership period. And that's it. With that, our appeal is dismissed. We say that's a wholly inadequate response to our very detailed appeal. And also, I have 5 minutes left, and there's one final point to address, which, if I may just squeeze in. It relates to our... So otherwise, I rely full upon my skeleton argument on grounds 3 and 4, and I take that as read. Mm-hmm. The final point to address is this. In the discussion yesterday about the relevance of the overhang period and the potential connection with penalty, I want to recall. Now, of course, overhang is relevant in damages claims brought by victims of infringement because, of course, the claim in respect of all losses suffered, subject to the usual tort rules that we referred to yesterday on foreseeability, may be reclaimed. We also know from this court's judgment in Sinvan, the liothyronine case, that the overhang period is relevant to identifying comparators in order to determine whether the price of a focal product is abusive. Of course, in that case, in Sinvan, the CMA didn't find any infringement once entry had occurred. Prices on the downward trajectory were not held to be abusive, even though they took a long time to reduce and stabilise, which is an important difference in this case. The question was put to me yesterday, was whether this is relevant to penalty, and if so, how? With respect, having thought about it overnight, it's a good question. I want to make sure I've answered it fully. So I have 3 points to make. First is this. What the CMA clearly cannot do should not be controversial. The overhang period cannot be relevant to duration because overhang period is not part of the infringement period. As my Lord Justice Zacaroli, the point my Lord made is there's a difference between an ongoing infringement and ongoing effects of an infringement that is finished. Now, in discussion with your Lordships yesterday...
So that's on the assumption that there is no abuse during the overhang.
During the overhang. That's the exercise which needs to be gone into, in fact. That's going back to yesterday, is to distinguish those two. In discussion with my Lord yesterday, there was reference made to an ongoing abusive price. And there was some concern behind it that there may be some confusion creeping in, so I want to make sure I've been clear that there can be no abusive price once dominance is lost.
So we understand that.
Yeah. But what there can be is a price that's artificially inflated as a result of a prior abuse. Yes. Is understood.
Yes.
Now, as we know, special responsibility means the dominant undertaking can't engage in conduct that's entirely legitimate for a non-dominant undertaking. But of course, a non-dominant undertaking can charge whatever price it wants. So once dominance is lost, the infringement is over, even if prices take time to fall. And the duration of the penalty has to reflect the fact the infringement is over. So that's the first point. The court has it. The second point is what CMA might conceivably do. If it thinks the particular infringement is likely to have overhang effects, it might take that into account when setting the penalty in respect to the infringement period. It didn't do that in this case, so I'm speaking in hypotheticals. But one can see that might consider it an aggravating circumstance that the infringement is of a nature that will take time, or did take time, to unwind. Or it might consider it relevant to the analysis of financial benefit likely derived by the infringer. Now, if the CMA did do that, one can envisage an appeal against that. Indeed, those to my left may want to say something on that subject. And I don't go so far as to say that the CMA was entitled to do this or should have done that. But I can see it might take that view of its powers. Mm-hmm. So the third point, and final point, is this then. The question then arises, who do you pin the penalty on? And this would be a question for the usual rules and attribution. The penalty imposed would be on the actual infringer and any parent company that meets the criteria for attribution. And what does that mean for a case such as Intas is? Again, speaking in hypotheticals, because this isn't what the CMA did, the analysis would be that the Accord UK, as the infringing subsidiary, has to answer for its earlier infringement, and it will be penalised. But there's no basis then, in that circumstance, for fining the two Intas parent companies. There's no infringement during the period of its ownership. They haven't participated in it, and even though they control the infringing subsidiary during the overhang period, they didn't control it during the infringement period. So there's no ongoing.
This is all on the assumption there's no dominance, no abuse.
Exactly. Exactly so. So that is going back to answer.
At the most basic level, if there's no dominance and no abuse,
then there can be no penalty.
there can be no penalty.
Even if the overhang period.
Section 36, it's in the event of an infringement.
Exactly right.
Or whatever the wording is.
Yeah. So the question that my lord asked me to finish, which I said I would come back to.
Going back to the previous ownership, there could be an aggravating factor that they could have taken into account, is that there was an overhang period during which
indeed
prices continued to, or didn't come down fast enough because of the previous.
That it took time to unwind, so that, if that is the analysis.
So the enduring financial benefit might be subject to what anyone, I see, yes. I think it must follow then from section 36, if there's no infringement, there can't be any penalty because the latter is contingent on the former.
Yeah.
Quite.
But you could whack the previous owners.
You could, if that was your analysis, which it wasn't here.
Which it wasn't.
Yeah.
Thank you very much. That's very helpful. Just in terms of on the assumption that you were dominant and were abusing, where do you say in the step 1 and onwards that should have been taken into account? What is your submission on the point during the step analysis under the guidance, your differentiated ownership of that infringing undertaking should have been taken into account? I know it could have been at different stages, but where do you say it should have been?
Either step 1, where you could have gone to the bottom of the scale of for that unfair, the typical scale is 20 to 30%. Rather than going to the top, you could have gone to the bottom, 20%. Of course, we know that is all subject then to the subsequent analysis of aggravating and mitigating circumstances. If you've done it at step 1, you wouldn't double count it.
Can I put my question in a different way?
At step 3.
If we're assuming there was a violation by an undertaking over a 10-year period, what's the logical point in time in which to deal with attribution? Maybe that's the better way of putting it. Would that still be step 1, or is it really at some other point? Well, you've got your overall liability, call it 100, and you're then dividing it up between different owners.
The most natural answer to that, on the basis of sort of how the CMA approached and analysed the abuse, would be at step 3, where you say the mitigating circumstances. But we always submitted, look, you can do it at step 1 or step 3, not both, but somewhere.
Well, you made the point about step 3 that if you were liable, then there were mitigating factors, one of which was that you were at least trying to get the price down.
Get the price down, not putting it up.
Well, try.
We hoped with some mitigation, and indeed some substantial mitigation, and then the specific deterrence uplift, of course, bore in mind financial benefit, where we don't differ from that as a matter of principle, but then the seriousness of the conduct. Again, that is a point at which, because this is now specific to Intas, what you're doing in terms of the uplift, you should be looking at Intas's conduct, or Accord UK's conduct during the Intas period. And then specific deterrence and the need for it assessed in that context. So where 400% comes from, we find very difficult to understand. Our submission would be something much closer to the 12.5 million financial benefit at most would have been justified. It's a different order from the 44.4 million. Oh, my time is up. You've indulged me for next.
Just coming back to the point you were making about the analysis, if there's no infringement, it must follow from. I'm just looking at the language of section 36. The CMA only has power, jurisdiction to impose a penalty, where only if satisfied that there has been an infringement. So there has to be a finding of infringement before there can be a penalty. Ergo, if there is no finding of infringement, there cannot be a penalty.
Oh, that's right. Yeah. I'm very grateful. Unless there are any further questions.
No, I don't. Thank you.
Thank you very much indeed.
Thank you. Yes.
My Lords, I propose to start with a very brief summary of the Tribunal's role in the context of penalties by reference to authorities that we've included in the bundle. I'm not proposing, given the time, to turn them up, but I will give the references. First of all, the Tribunal has a full jurisdiction itself to assess the penalty to be imposed. That's NAP at paragraph 499, authorities 7, page 392. It should both adjudicate on the specific complaints raised by the appellants and look at the matter in the round and form its own view as to the appropriateness of the penalties involved. And that's the Tomlinson case at paragraph 72, Authorities Bundle, tab 26, page 730. It should subject the CMA's decision to rigorous scrutiny and reach its own conclusions on the merits. That's Rowland at 36, Authorities Bundle, tab 50, page 1334. And if the ultimate penalty appears excessive or unjust, it should investigate and identify at which stage error has crept in. That's Keir at 74 to 77, Authorities Bundle, tab 24, 701 to 703. We also saw yesterday in paragraph 140 of Flynn Farmer that a full merits assessment is a matter of Article 6 rights, and it's necessary for the imposition of a quasi-criminal penalty. So it is not good enough for the tribunal just to do a quick sense check of the CMA's approach. In order to see the full picture in the context of my clients, one needs to look at each of hydrocortisone 1 on abuse, hydrocortisone 2 on the 10ml agreement, and hydrocortisone 4 on the 20ml agreement. You've been shown hydrocortisone 1 already. If we can just please turn back to, I think in fact we may be on it, core 16, page 470, please. You've been shown 373. This is the single paragraph summary of the appellant's submissions. Essentially that all the appellants challenge the penalty as being excessive and or disproportionate. You've also been shown 375 to 376, which are the sole two paragraphs of reasoning in which the tribunal upholds the CMA's penalty. The headline approach, as Mr. Palmer has indicated, is the CMA says at 375, taking the case as a whole, we see nothing in the CMA's approach amounting to a material error. Mm-hmm. What is more, the two
you say
single...
It's not quite rubber stamping, but it's not far off it.
It's barely different, my lord, yes, exactly. The two paragraphs of reasoning that we do get, 375, 376, are in our submission contaminated by the tribunal's error of approach in relation to the legal test for excessive pricing. So if we look at 376 subparagraph 1, this is in the context of its assessment of seriousness, and it's referring to a mismatch between cost and price. And it goes on to assert towards the bottom of the page, any business person with any understanding of the pharmaceutical business would have appreciated that these margins were only defensible if there was some legitimate means of differentiating the 10mg and 20mg focal products from competition. Such legitimate differentiation did not exist. In my submission, this is wording which is clearly harking back to the nature of the legal test the tribunal was applying that I addressed the court on yesterday. And then subparagraph 2, similarly, if we go over the page, we get a statement, again, just over halfway down this paragraph. Entrepreneurs should not expect to make profits in excess of cost plus through the illegitimate exploitation of market power. And in our submission, this is another example of the reversal of the burden of proof and of treating cost plus without more as sufficient. And subparagraph 3, we see again a repetition of this formula in terms of the approach that's being taken to penalty. The tribunal is not prepared to redo the exercise when the CMA's approach is not affected by material error. So that's what we got on hydrocortisone 1. In hydrocortisone 2, if we could look please at core tab 17.
Can I just ask you, you said that they basically just adopted it willy-nilly without any critical analysis of their own. If the CMA decision was impeccable, would that be an acceptable approach to simply say, we've analysed it very closely, we agree? What would be wrong with that if the CMA approach is impeccable?
Well, there's obviously a prior assumption there which the court will appreciate I don't agree with, but
yeah, of course.
Well, just make
even if the CMA's approach were impeccable, it is very clear that a very thorough and conscientious exercise needs to be undertaken in order to verify whether it is indeed impeccable or not. And in our submission, 2 paragraphs saying we are satisfied there's no material error simply does not do the job. And what we've done is include, similar to Intas, we've included our submissions that we made below in the core supplemental bundle, so the court can simply get an idea of the volume and scope of the submissions that we made. They're behind tabs 8, 9 and 10 of the core supplemental bundle for Auden, and then tab 14 for Allergan. And that will give the court a feel for the scope of the submissions that were made on this issue and the inadequacy of the reasoning that disposes of them in 2 paragraphs.
So there's 2 points, I think, there. One is they failed to investigate properly because they didn't engage at all with your reasoning, your appeal reasoning. The second is if they did do that, there's an inadequacy of reasons in the judgment.
My lord, absolutely, yes.
I think that's the right analysis.
Yeah. They may or may not have done that, but we don't know.
We don't know, and that is not right as a matter of procedure. And of course, I will then come on to say, in fact, the CMA's approach was not impeccable for the reasons that we'll come on to traverse. Hydrocortisone 2, page, core 17, page 615.
Yeah.
I should have there paragraph 159. There we go. I'm showing the court this because this is where the tribunal essentially declined to consider Auden Actavis's appeal in respect of penalty, in respect of the 10 milligram agreement, because of its concerns about due process, which were the ones that then came up to this court in the previous appeal. We then have Hydrocortisone 4, for tab 18, page 620, please. And this is the judgment in which the tribunal affirms the CMA's approach to penalty in respect of the 20 milligram agreement. Paragraphs 7 to 10 in this judgment summarise the CMA's decision. Our submissions are summarised at paragraphs 11 to 12 within this judgment, please. And that includes the point that we make again in this appeal, that the totality of the penalties for all the infringements was manifestly disproportionate, amounted to several times Auden Actavis's statutory cap. And again, if we look at paragraph 15, please, we see exactly the same formulation adopted. We do not find material error in the CMA's approach. And again, we say that's simply not the correct approach to penalties. Paragraph 15.1 agrees with the CMA that imposing penalties for each separate agreement was justifiable and that each infringement constituted a distinct abuse, which is a matter in which I'm going to come on to address the court. Subparagraph 4 over the page, we simply get the statement the CMA's approach does not obviate the statutory cap. Different penalties were imposed for different serious infringements. And then subparagraph 5, the decision makes clear that CMA did take a step back to assess if the aggregated penalties were disproportionate or excessive. It explains how the CMA avoided double counting and it assessed the fines as a whole. The court has the first overall point I make in respect of the totality of this reasoning, which is that it doesn't apply the right test and it hasn't supplied sufficient reasons. The second headline point I should flag up is that there is a difference of opinion between us and the CMA, which has emerged relatively late in the day, as to whether we have permission to appeal in respect of Hydrocortisone 2.
Yep.
We had always understood that we did have permission to appeal by virtue of the tribunal's reasoned order of the 4th of March 2025, and we say on a true construction it does give us permission.
Yeah, you said a matter of interpretation, but in any event, as a matter of course, you've now submitted an application out of time, and we will simply have, I don't know if we...
Well, we'll consider whether we want to hear detailed submissions on that or...
Not really.
I'm grateful. Well, I'm very happy to proceed on the substance in that case, and that was the purpose of the exercise.
We've got enough to deal with without doing that.
I'm delighted not to deal with it, but the court has the position as in our application, so we hope that does mean that we can focus on the substance.
If in insofar as we change our mind, we will let everybody know.
Grateful.
There's a major incentive there not to do that, isn't there? Because you'll then come back at us.
I will. So having dealt with the introduction, the first point on the substance is the question of intentional negligence after 29th of May 2015, and that is the point that Ms Thomas is going to address the court on.
My Lords, good morning. As you know and have heard already, the finding of intentional negligence is a statutory threshold to be met for any penalty to be imposed at all. And the CMA in the decision has found intention and negligence or negligence, as Mr Palmer explained, in relation to each of the unfair pricing abuses and the agreements. And it's done so on a compendious basis, including the period post 29th of May 2015. The significance of this date is that it's when Mr Amit Patel left Auden. Now, Mr Patel is the only person mentioned by the CMA.
So, which particular date in 2015?
29th of May.
29th of May. That's when Mr Patel left.
Exactly, my Lord, yes.
Yeah. He's the only person that the CMA identified as bearing a responsibility.
Exactly, my Lord, yes, you have a point. And indeed, in the decision, Mr Patel is the only individual on the side of Auden Actavis who's mentioned as a key individual in respect to the conduct. This is the decision at paragraphs 3.38 to 340, page 698, tab 22.
Sorry, I couldn't hear the page, the paragraphs.
3.38 to 340 of the decision, just for your note. And so the focus of the submission which we make on appeal is that the finding of intention negligence post 29th of May 2015 is unsustainable given that departure. And in this regard, obviously, some of the context of the points made by Mr Palmer is material which I adopt and don't repeat. The focus of my submission is going to be the finding of intention negligence post 29th of May 2015 in Hydrocortisone 1, including the fact that it's inconsistent with what the tribunal has done in Hydrocortisone 2. So far as the agreements are concerned, your Lordships will also have the point that the 20 meg agreement had come to an end already in April 2015. So of course there's no finding of intention negligence after that point in respect to that agreement. As to the 10 milligram agreement that's addressed in Hydrocortisone 2, the court will recall, 72 members may, that Auden Actavis had made a temporal argument as one of its grounds in its notice of appeal against the finding of infringement of the decision. So the argument that was made was that the common understanding giving rise to the 10 milligram agreement came to an end on the 29th of May 2015 with Mr Patel's departure. The tribunal rejected that argument because that's a point that came to the Court of Appeal, and the Court of Appeal held that evidence of the subjective state of mind of parties to an anti-competitive agreement wasn't necessary for the purposes of infringement. But the tribunal made a distinct finding in respect of penalty in Hydrocortisone 2. So this is Core Bundle, tab 17, page 604. This appears in a section of the judgment headed Later Phases, holders of the MSD MA after Auden. And you can see it, paragraph 136, the tribunal repeats that finding in respect of infringement that I just found, that the infringement continued after May 2015. But at paragraph 137, the tribunal was at pains to emphasise, specifically for the purposes of penalty, that we do not consider that any of the later entities acquiring the holder of the MSD MA did know intention or should have known negligence of the illegal aspects of the 10 milligram agreement. And in particular, at the bottom of this page, paragraph 137, subparagraph 2, we do not consider, and then over the page, that any later acquirer of Auden can be criticised for failing to appreciate that there was an improper agreement between Auden and AMCO. So this final finding of fact as to the absence of intention negligence when Actavis acquired Auden and Mr Patel left has not been appealed by the CMA. The implications of that for the calculation of the 10 milligram penalty may have to be considered by the tribunal when the matter comes back to it on remittal.
That's not a finding that the undertaking, as defined post 29th of May 2015, did not have intentional negligence, is it?
It's a finding of the acquirer, which I suppose refers. You're wondering if it's a finding with respect to the legal entity.
Yes. It's just it's referring to the entity that acquired, not to the undertaking, including the acquirer and Accord UK thereafter.
I think in my submission, the distinction that is being drawn is between whether the relevant subjective state of mind, intention or negligence, is held by the acquirer, which arises the language that the tribunal uses, after the acquisition takes place. And what I'll go on showing is that earlier on, in Hydrocortisone 1, the tribunal was very careful to distinguish between who the members were of the undertaking at the material points, and noting in particular that Mr. Patel, a member of the undertaking, had left as of May 2015. And after that point, the undertaking did not include that individual who was the one who held the relevant intention negligence. There's a further wrinkle in respect of the legal entities, which is that the business transferred from Auden to Accord UK in September 2015. But we say that's not the matter that the tribunal is focusing on here, and it's not a matter that can matter materially in terms of the substance of the finding of subjective state of mind with regard to intention negligence. So perhaps that gives me a good moment to come back to Hydrocortisone 1, which is what we're concerned with here. The issue, of course, is that Hydrocortisone 1 was decided first, and so before the tribunal reached this conclusion in Hydrocortisone 2, where it made this careful distinction in respect of intentional negligence before and after the acquisition. In Hydrocortisone 1, what the tribunal was careful to do was identify different periods at issue. So at Core Bundle tab 16, page 49, page 49.
And 429.
These are some of the colourful tables that Mr. Palmer showed to you yesterday. At paragraph 281 at the top of the page, you have the finding in relation to the Patel phase as the tribunal defined it. And this is the point I was just making in response to your lordship. The undertaking comprised essentially Auden and Patels. Paragraph 283. After that date, the undertaking includes now Actavis, the acquirer, but doesn't include Mr. Patel, who has left and is no longer a member of the undertaking. So we have this careful temporal consideration of who the members of the undertaking are at these points, for the purposes in particular of dominance. But we don't find any of this temporal analysis when it comes to either abuse or penalty being my focus now. The tribunal has already seen the penalty section of the judgment a few times. In respect to the intention negligence issue, the tribunal summarises the CMA's findings at page 466. And at paragraph 361 is the summary of the conclusion in respect to intention negligence. And this is the point made at paragraph 10.22 of the decision that Mr. Palmer showed you this morning. The CMA's conclusion is it's not necessarily to establish intentional negligence at the level of each entity held liable for the infringement, in light of the wording of section 36.3, which refers to intentional negligence on the part of the undertaking. But paragraph 10.22 of the decision, which Mr. Palmer has shown you already, is concerned with the submission that the CMA was required to provide, is concerned with the submission as to whether the CMA was required to prove intentional negligence before and after 29th of May 2015. So there are 2 points that have been confused here. One is about the concept of the undertaking and attribution of intention negligence within the undertaking. But the second point is a temporal one. Do you have intention negligence before or after a certain date? That's a separate issue. It's one that the CMA doesn't address in the decision. And it's actually one that it doesn't address in its skeleton in this appeal either. It continues to confuse those issues at paragraph 94 of its skeleton. The issue, in light of the finding that the tribunal has made in Hydrocortisone 2, is that the CMA does in the decision rely on the 10 milligram agreement as a material factor in respect of the existence of infringement and for seriousness in respect of penalty. So again, Mr. Brown has done some of my work for me. He showed you yesterday paragraph 4.230ci of the decision, which refers to the agreements as key context in relation to the issue of dominance. The CMA also relies on the issue in relation to unfair pricing. So at Core Bundle tab 23, page 1158. This will take us to paragraph 5.2a of the decision. And here, as the very first subpoint, where the CMA in the decision explains how it was that Auden Actavis's prices reflected market power and were therefore unfair in themselves, the CMA specifically relies on the idea that there is market power arising from the unlawful agreements.
Well, it's to preserve its market power. So the agreements deterred or prevented new entry and thereby preserved its market power because it wasn't subject to competitive pricing by new entry.
My lord, yes, I accept, of course, that's what the decision says. But that point I would submit is particularly material, bearing in mind, as I'm going to come on to submit, that what I'm focusing on here is the position after May 2015. So this is an acquirer who's aware that 10 milligram NA has been granted to a competitor in October 2014. It believes and expects that prices are going to come down shortly. This board already showed you the documents related to that. And therefore, in respect of whether that acquirer believes that there is an existence of market power, it's material to their state of mind as to whether they knew of the existence of the agreements or not.
Can I just ask you this? So under section 36, it's the intention of the undertaking that we're looking at. So it's the European concept as opposed to legal personality concept. And in the decision on abuse, the agreements are viewed as enhancing barriers to entry and preserving the monopolist's ability to maintain higher prices. In terms of intention, the decision recognises that there was new entry, and by definition, therefore, the agreements either didn't or no longer deterred new entry. Does that not mean that they did take this into account? And I mean, it also really begs the second question I want to ask you with what is meant by intention?
To address the first question, I think, with respect, this is the same confusion that I've suggested the CMA has engaged in. There are two distinct points here, really. We take no quibble with the concept of the undertaking. It continues and endures over time. We accept that Accord UK is the economic successor. That's the basis on which we're being fined, rather than as a parent company. And so the idea of the undertaking enduring through time is not relevant, really, to the point that I'm making. The point that I'm making is a temporal one about whether the subjective mental state of intentional negligence is satisfied throughout the period of infringement, in respect of which the CMA has sought to impose a penalty.
It may depend on what's meant by intention.
Well, as to the meaning of intention, I don't think this is really in dispute between the parties. It is addressed by the tribunal in its Hydrocortisone 1 decision, I think from memory at paragraph 175. I would be really Julian is assisting me with the reference. Here we go, I did have that right. There we go.
175.
I'm grateful, thank you.
So this is
so in fact, well, that does set up the statutory provision that makes it clear that it's the state of mind of the undertaking. And so that is in my submission.
well, the intention of the undertaking, it is. But,
yes.
But what is the intention in respect of? So you could have it in layers. I don't think anyone says, sometimes we see lazy language, I think, here. You don't have to intend to breach the Chapter 1 or the Chapter 2 prohibition. You don't have to intend to do something illegal in the sense that you have to know about the case law about Chapter 1 or Chapter 2. It's really about the acts, intend to do the acts which constitute on subsequent analysis.
And you have to know the facts that are material to knowing
So
that
then what, so which facts, because the Cat 1 says, well, they must have known they were dominant. That's a legal analysis, the word dominant. Do you have to know that you're dominant in a legal sense? I think the paragraph we've just been shown uses the word, must know we're dominant. Is that right? And what is the intention to do? Because, you know, in crime, it can be possession of a firearm. Did you possess it? Was it a firearm? intention to supply. I supplied you with drugs, but I intended to supply you with drugs. It's connected to something, intention. And it's not, I intend to breach the law, because otherwise, if you don't take legal advice, you get away without being fined. So what is it?
Well, I suppose I should say there are some grounds of appeal focused on by Allergan and Intas in particular as to the fact that the law of unfair pricing was in flux at the time, and that's a fact.
Well, I know, but is that relevant? I mean, what are the bare minimum facts? Here, you knew more or less what your cost was. You knew you were trying to extract profits at a higher and higher and higher level. You knew you were not constrained by a new entry. How much more than that do you need to have before intention can be imposed upon you? So that's why I want to know what facts it relates to.
Yeah, I completely see the point, my lord, and just to confirm that decision paragraph 10.14, that is how the CMA puts it.
We need to have that on screen, I think.
Of course, page 1619, tab 23, the core bundle, which I think is really summarising the way your lordship has just put it.
But then you've got the conduct would result in a restriction or distortion of competition, and then later on it uses, I think it uses the word unfair, and then later on it uses the word exploitative.
Yes.
So
perhaps that's compendiously summarised by being aware of the anti-competitive nature. But in the threefold summary that my lordship just gave, the third factor that was mentioned was the awareness that there would not be new entry, and that's really what this point goes to. In circumstances where there's a lack of awareness of the 10 milligram agreement, which is the thing that's preventing new entry, that particular factual item of awareness has not been established in respect to the period post-May 2015. And so
I understand that. I mean, I see that. And then that's why I think there are two questions. Did the CMA or the CAT inferentially take that into account when they recognised that the agreements came to an end and there was new entry? And intention then encompasses all of those facts. Intend, first of all, for there to be entry blocking agreements, and then when those terminate, for them to hang on as long as they could to higher prices and bring them down as slowly as possible. That may just be the continuum of the intention. That might take into account the point you're making. But that rather depends upon how they've analysed intention as the facts evolved.
It does, and the trouble with that is, and here there is some similarity with Mr. Palmer, he said, is one finds already an absence of that kind of analysis.
Yes, well that might be an answer. It may be that they just didn't address it.
I was in the process of showing you the sections of the decision that are relevant.
But can I just vex you a little bit more on decision 1014? CMA say, but whether it was aware of its anti-competitive nature. The concept of something being anti-competitive is a legal concept.
Yeah.
What are the facts?
Yes.
I mean, the facts are, I know my costs, I know the price I'm charging, I know the margin I'm getting, and I know that I'm not subject to competition, or I'm deferring it and pushing it back and back. Those are facts, commercial business facts, that I think one might impute the undertakings were aware of. Whether you actually put over them that's anti-competitive is rather referring that back to Chapter 1 and Chapter 2. And that's why we're sort of interested in precisely what fact, the bare minimum, from which the CMA could then deduce intention.
Yes. If I may, that's a deceptive question, and the reason why, therefore, I focus on how the CMA put it is because in the circumstances of this case, the facts that make the agreement anti-competitive, or that are relied on as making the agreement anti-competitive, are the ones identified by the CMA. And the CMA has repeatedly in the decision relied on the existence of the agreements preventing entry as a factor making Auden McTavish prices unfair. I've just shown you one part of the decision identifying that. Paragraph 440 to 441 of the decision, I think, is also quite instructive, in particular in light of this exchange. That's Core Bundle 1023, page 1190. This is the section of the decision dealing with economic value. And the CMA emphasises there, if we get to it, page 1190.
Paragraph?
5440. So what you find here is Auden Actavis bolstering its power and its ability to get away with high prices by preventing competitive entry through the market exclusion agreements. And then, quite importantly, my submission at 5441, Auden Actavis could not delay competition indefinitely. Once independent entry occurred, the prices of competing hydrocortisone tablets took time to be competed down. Such was the level of distortion created by Auden Actavis' very high prices over the previous 7 years. So what the CMA is saying, and an important factor that it's relying on as a fact, making the prices anti-competitive, to put things in terms of the discussion we just had, is that prices became extremely high because the price rises were supported by market exclusion agreements. And then even once the agreements ended, prices continued to be high, and that's an unfair level, because they took a long time to be competed down from that very high point. And just for completeness in relation to decision, Mr. Palmer also showed you this morning that the existence of the agreements was relied on respective seriousness.
And how does...
Can I just take you back a moment on
Yes.
intention and negligence? Because I had a sort of bell ringing at the back of my head, and actually in that passage you just showed us in the CMA decision on penalty, they refer to Ping, which is in the bundle, and we did deal with this in the Court of Appeal on Ping.
Yes.
At paragraph 117, which you've got in the authorities bundle at page 1208. And that there, I think from recollection, reading Justice Rose gave the main judgment, but an infringement is committed intentionally for this purpose if the undertaking must have been aware or could not have been unaware that its conduct had the object or would have the effect of restricting competition. And then a similar point about negligence. Ignorance or mistake of law does not prevent a finding of intentional infringement.
And that's, of course, that was an object agreement
That's an
case.
objective,
So you'd have to translate that into an abuse case. And that's why what you would say, I think, that they were aware or could not have been unaware that it was unfair or exploitative. And then below that, you say, what are the facts?
Yes, my lord.
Which the CMA has to establish, from which you can then label it intentional.
Yeah.
Yes, my lord, I agree with that. I think that's consistent with what the CMA says at 1014 of the decision. But it's also consistent with the submission I'm making, that a material fact that the CMA has repeatedly pointed to as rendering the prices abusive is the fact that prices climbed so high because of the agreements.
Yeah.
And we now have a factual finding of the tribunal, unappealed, which says that the intentional negligence in respect of that aspect doesn't continue up to May 2015.
And then you took us to 5441, where there's an acknowledgement by the undertaking that you couldn't deter entry forever.
Yes.
And then the question arises is, how does the CAT and or the CMA treat that in terms of intention? Because if a company says, well, I'm going to hang on as long as I can and deter entry, and I know there'll be a period in which entry occurs, and I will deal with it when it arises. And the intention is part of that overall strategy. Keep going for as long as you can and then cope.
My lord, yes.
And the question is whether that is reflected in the CMA's analysis or the CAT's analysis of intention. Because if it is, doesn't that undermine your point? It sort of takes your point as read and says it's part and parcel of a broader intention, hang on, and then deal with it as it arises.
Well,
because that's the overall intention.
The intention to build a price as high as possible and unfairly high, and a factor going to unfairness being the existence of the agreements, is the central feature that makes the prices so unfair and that enabled the prices to climb as high as they did. And then the glide path down and the extent to which one is aware that those prices are unfair depends on knowing the reason why they have got to the height that they had in the first place. I can put it that way. And your lordship asks, well, how did the CMA deal with this and how did the tribunal deal with it? And the problem we've been left with is that there's now a departure between the CMA and the tribunal. We have the tribunal's finding the absence of intention negligence in respect to the agreements after May 2015, but your lordship has already been repeatedly shown Hydrocortisone 1 and its analysis of intention negligence there, and how thin it is, and the tribunal's misdirection as to what it actually needs to ask itself in relation to that standard. So I don't think I need to show it to the spec, but to emphasise, this question of whether intention negligence continued after May 2015 was in Auden Actavis's notice of appeal, and that submission isn't even mentioned in Hydrocortisone 1. So this particular problem isn't considered at all, and still less is the problem considered in light of the fact that the tribunal has made a different finding from the CMA in relation to intention negligence of the agreements after May 2015. So that, in essence, is the point, really. Auden couldn't have known, Actavis couldn't have known, when it inherited the prices from Auden, that the reason why they were as high as they were, and therefore how far they had to fall to reach a competitive level. All that they knew was that an MA for a competitor had been granted in October 2014, so they expected prices to fall, as they did. Mr. Patel had left, he was the one who knew, and that fundamental change of facts on the ground is not addressed anywhere by either the CMA or the tribunal in relation to this point. And so the submission is that the tribunal's finding of intention negligence in Hydrocortisone 1 in those circumstances is unsafe and can't be upheld.
And that all hinges on, it's Allergan, isn't it, which comes in at this point. It was called Actavis PLC at the time, but I just for my purposes, we're talking about Allergan.
It gets renamed Allergan.
Yeah, so the entity called Allergan acquires in May 2015.
Yes, and Mr. Patel.
And Mr. Patel
really
leaves.
key point, yes, my lord.
Yeah, but your submission depends upon the finding that the acquirer, Allergan, had no intention or negligence as to the 10 milligram agreement from that point onwards.
Yes, well, my submission is that the company, having been acquired, has no intention.
Well, that's not the finding, but you say that should be read in that.
That must be what the tribunal means, including because of the way that it approaches the Patel phase and the other section of the judgment.
Yeah. Can I just ask a very basic question? Apologies for this, but Auden McKenzie was the entity holding market authorization until the same time, actually, when Allergan's, well, just slightly later, Allergan's subsidiary in September,
yes.
Yeah, which is Accord UK, previously called Actel. Yeah. So you've got two companies. None of Auden McKenzie, the prior holder of the MA, doesn't feature in this at all as a separate entity.
It's not even been fined.
No, and that I assumed is because of the theory that the economic successor, because they were controlled by the same parent at the time of the transfer, the economic successor is liable for the whole.
Yes.
That's right, isn't it? How does that work then when you're looking at intention? Because the prior market authority holder had intention. That must be right, because Mr. Patel was controlling it. I think you would say that in Hydrocortisone 2, the tribunal found that the intention, including of the entity holding the market authorization, ceased on that date.
Yes.
But does that mean, because it's the economic successor and is liable for the entire period, that the fact it had no intention is irrelevant because it's just stuck with the prior intention of Mr. Patel?
This is why I emphasise that this is a temporal point.
Yes.
So Accord UK, as the economic successor, can be liable in respect of the period, whenever the starters, 2008 until May 2015. A fine can be imposed in respect of that period, and Accord UK, as the economic successor, can be liable for that penalty.
I see.
Obviously, the fact of the reduced duration may lead to a recalculation of the fine, a reassessment of seriousness. We'll argue about all of that in Hydrocortisone 5 if we need to. But the issue is that there can be no liability to a penalty in respect of Accord UK's conduct after May 2015. So that's why I insist that this is a temporal point rather than one to do with the metaphysical concept of the undertaking.
Yeah, I see.
My lord, that's probably a good moment to hand you back to Ms. Ford, who will talk to you about Accord UK.
Moving from the metaphysical back to the practical.
Indeed.
I'll try to live up to that introduction. Moving on to specific deterrence and the uplift that was imposed in specific deterrence. Mr. Palmer has already addressed this from the perspective of Intas, but we also challenge the absolutely swingeing uplifts that were imposed purportedly for specific deterrence at stage 4 of the finding process, and we say that they are disproportionate, unjustified, and should be set aside. We do need to go back to the decision for this because it wasn't addressed in the tribunal's judgments. If we look please at core tab 23, page 1714. This passage I think Mr. Palmer has already shown you. 10.284 is explaining the approach being taken to uplifting at step 4, and it says the penalty is being uplifted firstly to exceed the CMA's calculation of the financial benefit it says is attributable to the infringements, and also to have a deterrent effect on the undertaking as it currently exists, as well as taking into account the specific factors of the case. And then the paragraphs which follow spell out exactly what uplifts are being imposed on this basis. So 2.285, the periods A1 and A3, for which Accord UK is solely liable, the penalty goes from what was previously 40.6 million to 87.65 million, so a 116% increase in the penalty. Then if we look at 10.286, the period A2, for which Accord UK and Allergan are jointly and severally liable, it goes from 6.8 million to 37.9 million, so that is a 457% increase in penalty. 10.288, there is then a further uplift to 74.3 million, which is a remarkable 1000% increase overall, and that's imposed on Allergan, essentially because Allergan is large. And then 10.290, this is period A4, which Mr. Palmer has already shown you, for which Accord UK, Accord and Intas are jointly and severally liable, and that went from 8.9 million initially to 12.5 million, so a 40% increase in respect of the CMA's calculation of financial benefit. But then there is the uplift to the 44.4 million, so in total a 400% increase, for which Actavis is jointly and severally liable with Intas. We look at 10.302.
The big percentages only really matter if you start with the assumption that the starting point is the norm. If the starting point is merely the starting point to get to what will inevitably normally be a much bigger figure, the fact you get big multiples just means they're big multiples.
Well, my lord, I would actually make the opposite submission, which is when one has been through the prior stages of this process, including taking a starting point which purportedly represents seriousness and has been started, as Mr. Palmer showed you, at the highest level, at 30%. 30%. You then take into account duration, and then you then factor in specific factors in aggravation and mitigation. Once you've done that supposedly step-by-step process, it completely wipes that away to then say, well, having done that thought process, not to worry, we're now going to multiply it by 400%, or we're going to increase it up to this level.
Always subject to the statutory cap, which is the protective.
Well, indeed, and that is the other aspect of the complaint we make, because the total aggregate effect of the fine imposed on Accord UK is that we are fined coming up to 4 times our statutory cap. So when your lordship says that is the protective mechanism, in this case it hasn't worked.
Depending on how you define the infringements. Yes.
Well, that is exactly the point, and I'm going to come on to address them, yes. So, 10.302 on page 1720, please. So we're here dealing with the 20 milligram abuse, and the CMA applies no uplift for periods B1 and B3 because the amount that had been reached by the end of step 3 in that circumstance had already exceeded the financial benefit that it calculated. But then for period B2, it goes up from 1 million to 2 million, so it doubles. Note, please, on page 1722, paragraph 10.311. there's an explanation here that no uplift is applied in respect to the 10 milligram agreement because any benefits attributable to the agreement are captured in the financial benefits relating to the 10 milligram unfair pricing abuse. And we see a similar statement at page 1726, please. Paragraph 10.328, and this is in respect to the 20 milligram agreement, and it is saying for the same reasons it's not taking any additional financial benefits into account at this stage of the penalty for the 20 milligram agreement. In our submission, what this is very rightly recognising is the heavily interrelated nature of the infringements that have been found in respect of abuse and the infringements that have been found in respect of the agreements, and it's acknowledging that the financial benefits are the same in respect of both, and I'm going to come on to rely on that when we say that it was not right to split these up into separate infringements to try and fine us 4 times over. Our submission is that these uplifts, at the end of a process that was supposed to be calibrated to take into account factors such as seriousness and the individual situation of the companies in question, the entities in question, we say that it's resulted in an amount which is excessive and disproportionate. It's important to bear in mind that the entity actually being fined at this stage, as per the exchange with my Lord Justice Zacaroli, is what is now Accord UK, formerly Actavis UK. It is not the Auden entity. And so the question at this stage is, what penalties are necessary for specific deterrence in respect of Actavis UK, now Accord UK, beyond that has already been factored into this fine for the purposes of general deterrence? And we say no additional uplift is necessary in order specifically to deter the entity that is now being fined. We say that for a number of reasons. We say, firstly, the Department of Health undoubtedly possesses relevant price control powers in this case. The tribunal made findings to that effect in Hydrocortisone 1, paragraphs 100 to 104. So if there were any future cause for concern regarding prices, there are statutory powers to address it, and that is a relevant distinction from some previous pharma cases where there was something of a lack of clarity about whether the Department of Health did indeed have such powers. The tribunal has found that there are such powers.
But they've never exercised.
They were not exercised during the relevant period, but what we are now looking at is whether it's necessary to hike the fine up in order to deter the Actavis UK entity. And in our submission, it is relevant to take into account at that point the fact that the Department of Health has the powers to address this conduct.
Has a power which is never actually exercised.
Well, it didn't during the relevant period, and that was something we very much relied on.
I appreciate that.
Mm.
I mean,
Second,
I'm not really saying you're not right about the point, but it is relevant that it's a power they've never really exercised. So it's a factor, but it's not that strong a factor.
My Lord, I can't deny as a question of fact that they have not stepped in to address this.
And we had this incident, if you have the CMA as your sibling regulator, you might just simply say, I'm going to leave it to the competition authority.
Well, in my submission...
Because they're not competition authorities. I mean, the department is not exactly blessed with it. I have to be very careful about what I say. It's not an economic regulator. And it may simply say, well, there is a specialist regulator, and I leave it to them. And that's what I think we've seen in quite a few cases.
In my submission, the CMA has an ex post power to intervene when something has gone wrong, but the Department of Health does have a targeted power to address this particular scenario. And true it is that it doesn't seem to have seen fit to deploy it, but it is a factor, we say, in our favour when one asks, well, to what extent is it necessary to impose a swingeing fine to prevent this entity from engaging in conduct in the future? In our submission, it's a factor in our favour that there are specific rules which govern this conduct. The second factor we rely on is concerned with the 10 milligram agreement, and it's essentially related to the point that Ms Thomas has drawn out. Actavis UK is being fined only as Auden's economic successor and not on the basis of its own conduct. And it has been expressly found by the tribunal not to possess any intentional negligence in respect of its period of ownership of Auden. and that goes to the necessity for specific deterrence in respect of its conduct. In respect of the 20 milligram agreement, that ended before the 29th of May 2015 when Actavis acquired Auden, and so Actavis can't be said to be responsible for that conduct. As to the unfair pricing abuses, and even if we assume for this purpose that Actavis is to be treated as acting intentionally or negligently after 29th of May 2015, on any view, it can't be said to have instigated the conduct in question, and on the contrary, as we saw from the contemporaneous documents yesterday, it expected imminent generic entry to rapidly erode prices. So we say the very most that could be said in terms of conduct to be deterred is that Actavis failed to bring prices down even quicker. We also take issue with the idea that Actavis itself received significant financial benefit from the conduct in question that justifies an additional uplift for specific deterrence. When it purchased Auden, Actavis paid money to purchase what it thought was a profitable business. It didn't benefit from any sums that were received by Auden before the date of purchase, and any sums to be received after the date of purchase were reflected in the amount that Actavis agreed to pay for the business. So Actavis is no better off. It has paid a price which reflected anticipated future earnings. And of course, in this respect, it's relevant to remember that Actavis has a distinction from Intas in that it wasn't aware of the CMA's investigation. It had no notice in that respect of any problem, and so it paid a sum for the acquisition of the entity without any anticipation that the profits were unlawful. We do say that there's a further artificiality which arises from the focusing on profits relating to hydrocortisone tablets in isolation, and that is the point that we canvassed yesterday concerning portfolio pricing, because to the extent that profits from hydrocortisone tablets were used to lower prices on other drugs, it gives a distortive perspective to focus solely on the financial benefit in respect of hydrocortisone tablets without factoring in correspondingly lower prices on other products.
Was any evidence put before the tribunal and the CMA about that exercise in hypothecation? You know, we've earned excess profits on A, we'll allocate X percentage to Y. And what Y is? Is it a research-based product? Is it another generic?
Your Lordship drew my attention to the relevant passage in the tribunal's judgment yesterday, where it made the observation that we hadn't put specific evidence in respect to portfolio pricing. It was addressed at the level of submission, but we do say that insofar as there is an assumption that it is a correct exercise to look at hydrocortisone profits in isolation and uplift in respect of that financial benefit, we say that's a further crack in the shell in terms of justification for imposing massive increases in what would otherwise be the applicable fine. The CMA has given no specific reason for thinking that Actavis will engage in any further breaches of competition law in the future, and nor in our submission could it plausibly do so. And so, in all the circumstances in our submission, extraordinary uplifts of this scale are completely unjustified in our submission. I'm moving on to my final point before I hand over to Mr. Johnston, and that's to address the imposition of 4 separate penalties. And we say, in a nutshell, that it's wrong in principle and excessive and disproportionate for the CMA to fine Actavis 4 times over in respect of what amounts to a single course of conduct in respect of the same drug. As the Court is well aware, what the CMA has done is to say we're imposing 1 fine for unfair pricing in respect of the 10 milligram strength of hydrocortisone, a second fine in respect of the 20 milligram strength of hydrocortisone for the purposes of unfair pricing, a third fine in respect to the 10 milligram agreement, and a 4th fine in respect to the 20 milligram agreement. And this is, in our submission, an important point of principle, because what the CMA is doing, and what has been endorsed by the tribunal, is an approach to the imposition of penalties which essentially circumvents the protection that is intended to be afforded to an undertaking by virtue of the statutory cap in section 36, subsection 7 of the Competition Act of 1998. In this case, Accord UK's statutory cap is 28,000,000 £378,300. If we look at the total aggregate penalty for Accord UK, I think it's a table you've already seen. Core tab 23, page 1746. Down the page, please. There we go. So this is the table that Mr. Palmer showed you in the context of Intas. If we start by looking at the amount that it is fined Accord UK on its own, it's been fined a total of 67.7 million. How is that achieved? Well, first of all, the court looks at the figure of 28,378,300 in relation to 10 milligram unfair pricing. That's for periods A1 to A3. So it's been fined up to its statutory cap once for 10 milligram unfair pricing. We then look down and see Accord UK has been fined 8,082,000 odd for periods B1 to 3, 20 milligram unfair pricing. We go down again, we see it's been fined the 28 million figure, so up to its statutory cap again, for periods C1 and 2, the 10 milligram agreement, and then an additional 2,798,000 odd for the period of the 20 milligram agreement. So a total of 67.7 million, even though the 28 million figure is Accord UK's statutory cap. And that
The statutory cap is per offence.
Well, that is exactly the point. The question is whether in exercising a fining jurisdiction, it is appropriate to break a course of conduct, what we say is a single course of conduct in respect of a single drug, down into separate perceived abuses, separate perceived infringements for the purposes of penalty, when the consequence is that one is essentially circumventing the statutory protection that that Parliament intended an undertaking to have.
Should we start with the statute then? Sorry.
Sorry, no, you go first.
Yeah.
Yes, it's at Authorities Bundle, tab 67, page 2245. Sorry, 2245. And it's the subparagraph that's highlighted in the red sidelining.
Of the turnover undertaken.
So the only qualifying limiting words are under this section.
Can we just run up the page to see the beginning of the section? No, further than the previous page. It may be. I mean, what will be said against you is that there were two offences, one under Chapter 1 and one under Chapter 2.
My Lord, they in fact rely on 4.
Yeah.
Yeah, I follow that, but there's certainly 2.
Well,
The two main ones, the two figures that go up to the statutory cap, which is the 228 million. It was said against you that even if you were right about the rest, at least 56,700,000 is justifiable.
well, in our submission,
Under the statute.
in our submission, the question is whether it is appropriate to fine in respect of, or break it down in respect of the sub-component infringements for the purposes of imposing a penalty. There are two. I should perhaps, just before we move off this, show
Isn't the point here that in a sense, obviously the Chapter 1 prohibition is, if you like, is setting excessive prices, right? Abuse of dominant position by setting excessive prices. And the Chapter 2 prohibition, in very local terms, is taking steps to keep other people out of the market in order to continue your maintaining the excessive prices that you set previously. And I mean, my recollection of Hydrocortisone 2, I have reread the judgment, I wouldn't pretend to reread everything, is that the view was formed, it was pretty egregious conduct. So that it seems to me the CMA would be entitled to conclude that there were two separate offences which attracted different penalties. Now, whether to set a penalty as high as they did, so that it's effectively the statutory cap, is a different question.
My Lord, 2 points in response to that. The first point, insofar as the CMA takes a view that this was egregious conduct, that is taken into account at stage 1 of the penalty guidance in setting the starting point. So, and it set the highest starting point. So that, in my submission, has been taken into account. Mm-hmm. And then the second point is, in the circumstances of this case, although it is right to say that at a level of principle, an Article 101 infringement is a distinct, is a different sort of conduct from an Article 102 infringement at a level of principle, what we have seen on the facts of this case, and indeed relied on in the CMA's case, is the interrelationship between the Article 101 conduct and the Article 102 conduct. So Mr. Palmer showed you 10.172D, which is one of a number of places in this decision where the CMA comments that each agreement sustained a separate unfair pricing abuse. They are not unrelated conduct. The agreement is said to sustain the abuse. For that very reason, the CMA didn't double count the financial benefit, because the financial benefit stemming from this conduct is, on the CMA's own case, the same. Yeah. So in our submission, it is formalistic to make the point that there are infringements that relate to unlawful agreements and infringements which relate to abuse of a dominant position in circumstances where they form part, on the CMA's case, of a cohesive whole leading to the same financial benefit.
You're not suggesting, I think, that there was no jurisdiction to do this.
I don't make that submission.
So it's a proportionality standing back point only.
It is a proportionality point, and it is a point on the construction of the legislation in circumstances where, and I got slightly sidetracked before I was going to show your Lordship the authority, the function, the tribunal has previously explained the function of this section of the Competition Act is to prevent a penalty for violation of competition law for imposing an excessive burden on an undertaking. That's Eden Brown at 57, Authorities Bundle, tab 27, page 744. Now, if the purpose of this section is to prevent an excessive burden being imposed on an undertaking, then the consequence of taking an approach which breaks down an overall course of conduct into component parts and finds them multiple times over is to undermine that statutory purpose by imposing, by definition, an excessive burden. And the consequence we see here is that Actavis is fined almost 4 times over its statutory cap, once we take into account the element of the penalty that Mr. Palmer showed you that we're jointly and severally liable with Intas. Almost 4 times the statutory cap. That is not, in our submission, achieving the statutory intention of preventing the imposition of an excessive burden.
One of the measures of whether something's excessive is whether it has a deterrent effect, which you then measure against the turnover of the undertaking and the group turnover. So if you get to the point that a fine is, let us say, 100 million, but that's still only 0.something percentage of global turnover, is that not relevant also to whether or not the fine is excessive and disproportionate? That's why there are these. Well, there's more than one step, isn't there, in the analysis?
My Lord, yes, and that is the factor that is then supposed to be taken into account in the stage 4, which I've addressed the court on.
Yeah.
So there are stages which are supposed to take into account seriousness, and stages which are supposed to take into account necessary deterrence. The court has my submissions on the circumstances of the case on that. But at the end of that process, this statutory provision is intended to provide a safeguard in terms of ensuring that what comes out is not an excessive burden. And in my submission, it's not doing its job if the approach that's taken is to break it down in a way which we say is artificial. Now, I've addressed the court on one of the distinctions that's relied on to break it down, which is the distinction between Article 101 conduct and Article 102 conduct. What's even less justifiable in the light of the judgment of the tribunal is to maintain a distinction between 10 milligram hydrocortisone and the 20 milligram hydrocortisone. That was a distinction without a difference, even on the basis of the CMA's own case, because it had found that 10 milligram and 20 milligram hydrocortisone tablets were part of the same product market, at least prior to generic entry. And in terms of the conduct, it characterised the 10 milligram agreement as an extension of the 20 milligram agreement. That was its defence, paragraphs 49 to 56, which is in the supplemental bundle, tab 39 at 895 for your Lordship's note. That was the position on the CMA's case. Of course, the tribunal has since quashed the CMA's market definition, and it has concluded that 10 milligram and 20 milligram hydrocortisone tablets are substitutable for each other and form part of the same market for the entirety of the relevant period. And we say, on any view, the tribunal's findings, in contradistinction to the CMA, its conclusion that these are all part of the same market, ought properly to have fed through into the tribunal's assessment of what was the correct approach to penalty. And it should have concluded that there was no relevant distinction between 10 milligram and 20 milligram hydrocortisone tablets, either in respect of the penalty for unfair pricing abuses or in respect of the penalty for the agreement. And the fact that it failed to follow the logic of its own conclusion in respect of market definition in our submission is a further flaw in the tribunal's approach.
Well, the other way of looking at that, I mean, I follow that point in relation to the Chapter 2 prohibition, and it seems to me it has some faults. But in relation to Chapter 1 prohibition, there were two separate agreements. I mean, it may be the product is interchangeable. The fact is there were two separate agreements, the 20 milligram agreement, which we looked at in this court in Hydrocortisone 2 appeal, and the 10 milligram agreement, which had a different period. From recollection, was backdated, but I can't remember the details. But one of them was backdated.
Yes, you're
so you can see why, logically, even if you're right about the point about the CAT's approach to them being the same, as it were, the same product in the market, they're still entitled to say, well, there were two agreements that were infringed. So that can be reflected in the fine. Now, it may be that the overall goes back to the point about the overall fine. But,
my Lord, in response to that, there is no doubt that the CMA can alight upon differences. It can say, look, there were different agreements, they had different durations, they had different parties, they related to different strains. It can find differences. In my submission, the relevant question is whether those differences justify splitting up what, on any view, on the CMA's case, was a global course of conduct into multiple fines for the purposes of fining purposes. And in our submission, those differences do not. And if one is to do so, the consequence is to undermine the statutory intention. I'm mindful of the time. Unless your Lordships have further questions on that section, I'm going to hand over to Mr. Johnson.
Thank you very much.
My Lords, my submissions will address the question of penalty specifically as it applies to Allergan. I'm mindful of the time being slightly in the graveyard slot, as it were.
That's 2 till 3. Don't worry, that's Mr. Holmes.
That's Mr. Holmes. the digestive window.
Exactly.
Having lost the microphone, I'm trying to restore it. So I will be terse, and at certain points I'm going to just give you references and pass over some of the submissions by reference to the skeleton. But in outline, I propose to provide a brief introduction and then address you under 4 headings. First, very briefly indeed, the judgment. Second, and again very briefly, intention and negligence as it applies to Allergan. Third, the uplift for specific deterrence. Ms. Ford has addressed you on her 400% uplift. Mr. Palmer on his 400% uplift. I have my 1,000% uplift. And finally, proportionality in the round. So starting with the background, I can cover that, I hope, in 5 points. First, as you know, Allergan is a global pharmaceutical company headquartered in America. And on the 29th of May 2015, one of Allergan's UK subsidiaries purchased a further subsidiary, Auden McKenzie. And in July of 2015, so less than 2 months later, both of those subsidiaries were sold to Teva, and indeed the entirety of Allergan's generics business was sold to Teva. And following that sale, the Allergan group has completely stopped manufacturing generic pharmaceuticals. Second, Allergan's liability in this investigation is exclusively in its capacity as a parent
company. It is not the CMA's case that Allergan was directly involved in any of the alleged infringements. Its period of liability originally ran from the end of May 2015 to August 2016, when the tether sale completed, so a window of 14 months. But as you know, before the CAT, Allergan successfully established that it's not party to any infringement beyond March of 2016, because from that point on, the subsidiaries were in a whole separate arrangement. So Allergan's period of liability is now from the 29th of May 2015 to the 10th of March 2016, so it's a period of between 9 and 10 months. Third, in respect of that really quite short period of time, Allergan is currently liable for a penalty of around £75 million. And that is almost exactly a third of the entire penalties in relation to the 10-year period of infringement. So in respect of Allergan's 9.5 month window, a third of the liability in respect of the entire 10-year infringement window. Fourth, and critically, Allergan called Mr. Rob Stewart as a witness at trial. He's the CEO, was the CEO of Allergan at the relevant time. And his written evidence was that Allergan knew nothing at all about the alleged excessive pricing, and that also Allergan had no possible way of knowing, and did not know, about the alleged 10 milligram agreement, or the 10 milligram agreement. It's no longer alleged. I can only give you a flavour of that in the core supplemental bundle at tab 13, page 111, and paragraph 417 there. So scrolling down to 417, for the reasons set out above.
This is witness things.
This is his written witness evidence.
Which page of the course up?
111.
111.
On 4.17. I do not accept that the evidence cited in the decision supports the CMA's central argument that Allergan approved a strategy of improperly or unlawfully exploiting Auden's position in hydrocortisone tablets, nor have I seen any evidence to indicate that those involved in acquiring Auden were aware or even considered the possibility that it was engaged in any anti-competitive agreement or conduct, or that there was even a risk that this might be the case. Now, critically, the CMA elected not to challenge that evidence at trial in cross-examination. So Mr. Stewart was cross-examined, he wasn't tested or challenged on that. So it was not the CMA's case before the tribunal, and it cannot be the CMA's case before you now, that anyone in Allergan had any idea at all about these infringements. Now, that suggestion is present in the decision, and that's what Mr. Stewart's responding to here. And for your note, at paragraphs 9136 and 9158, that suggestion is canvassed, but it wasn't pressed at trial.
Can I just ask about, you said that's a flavour, but that's actually sufficient evidence, isn't it? I do not accept the evidence relied upon supports a proposition. It's not evidence. So why would you cross-examine it?
Well, what he's saying here with respect is, and he's obviously referring to what's above, and it may be worth you reading the totality of the statement. I don't think we should do it at the moment. But what he's saying is, it has been suggested by the CMA that those within Allergan knew or should have known about these infringements, and his evidence is we did not know, and there was no basis for us to know about these infringements. And that was directly in response to the decision. Now, the framing of it, I do not accept the evidence, my lord, to the extent that you consider that a submission. What he's doing in my submission is saying this is what has been suggested by the CMA, and it's my evidence that that's not correct on the facts.
This is slightly boilerplate, this sort of clause, isn't it? I mean, with this paragraph, you would put this into a statement. It's carefully crafted. I don't accept, so I've seen the evidence in the decision, I don't accept it supports the central contention, all right, that's his view, doesn't actually break down line by line what the decision says. Nor have I seen any evidence, doesn't say what anybody else has seen or not seen. I mean, these are quite carefully crafted.
Well, maybe worth his state of mind was at all.
Sorry, my lord,
It doesn't actually say what his his personal state of mind was at all. Well, does it not accept the evidence cited in the decision? Doesn't it's as my Lord Justice Zacaroli said, it's not really focusing on evidence at all. It's more by way of solution. I'm not.
Well,
not subtracting from your point that if one were going to challenge whether somebody at Allergan knew something, one might have expected cross-examination along the lines of saying, "Well, Mr. Stewart, you say this in your witness statement. But who have you spoken to? Who know? You know, how, was he actually the chief executive officer at the time?
The COO at the time.
COO.
So his involvement, and he explains in some detail his involvement and the relationship between the US side and the UK side. He explains and he talks through.
He's CEO of UK.
No, he's CEO of Allergan
US.
So he's based in the United States. So he explains in his witness statement, and he talks through some of the documents referred to by the CMA. He addresses those documents. He explains his understanding of those documents. Maybe I've taken you, because of time, too succinctly to the.
If you want to give us, if you want to make points and give us something to read, we will certainly do that.
Well, so my lord, perhaps the most sensible thing to do, if I can take you to just one more paragraph, which perhaps is again a summary paragraph, we can go back to 110. 4.12.1. So this is again having been through the documents and addressed them before starting at 4.1. 4.3 is documents referred to in the decision. He talks through them, and again at 4. There's no suggestion in any of the contemporaneous documents that any of the activist staff, or indeed any of the other bodies, because there's a question at this point about PwC are engaged. They're looking at this. They don't raise any questions about this either. And the due diligence process even considered that Auden's marketing and sale of hydrocortisone tablets was unlawful. So, my lords, given the time, it might be sensible to suggest that you read the entirety of part 4, if I can put it that way, of his witness statement, and in conjunction with that, and importantly, the document that I hope you have at the reference supplementary bundle at tab 70.
Part 4, you mean the paragraph?
Paragraphs that start 4 point and so on and so forth. And can I just confirm, because it may not be in the electronic version of the bundles, that the bundle may finish at tab 69, but at tab 70 there is a note of the reference supplementary bundles. It starts at page 1985. If I can encourage you to read the entirety of that, because that provides a summary of the oral evidence.
1925.
1885.
Yeah, we've got it in hard copy for sure.
Brilliant. I'm very grateful. And it appears to be. Yes, it should be 1919. Yes, there you go. I'm very grateful. So, my lords, if I can encourage you to read that as well.
Yes.
But the thrust of both the written evidence and
this was your note on the evidence.
This is our note on the evidence following the evidence at trial, following cross-examination. One of the points that's made, of course, in that note is that Mr. Stewart hasn't been tested in relation to Allergan's knowledge.
Yes.
In relation to these infringements. Now, there's a part of that note that deals with other points that went to the whole separate arrangement, because that obviously was very hotly contested for the tribunal. CMA's lost on that and it hasn't appealed. But I hope that by reading the two of those together, it is a perfectly fair submission that, as my lordship just put it to me, at the very least, if the CMA was going to advance the case that Allergan knew or should have known about these infringements itself, it would have put that to Mr. Stewart. And I don't think that's contested because it forms no part of my own friend Scallopin arguments here that was challenged. The point is a different one, which I'll come on to address you on in a moment, very briefly, which is we don't need to deal with intention at the level of Allergan. Intention and negligence is all dealt with at the level of undertaking. So it doesn't matter. It doesn't matter at all. That's the CMA's position. Yeah. But I do say it's significant because, of course, it feeds, and I'll come to this in a moment, it feeds into 2 points in the analysis. It feeds into intention and negligence, which I'm going to deal with, but only very briefly. But it also deals with the proportionality of the uplift. Because when we're asking, is it necessary to deter a company from committing similar or like or other infringements of competition law again, in circumstances where it's not the regulator's case that they knew or should have known, then it becomes very difficult, in my submission, impossible to justify what I think is the largest ever uplift in a penalty in UK competition law history. And I'll be delighted to be corrected on that, but 1,000% up. So I say it's relevant to both stages of the analysis, if I can put it that way. Fifth, and finally on the background, that failure to challenge Mr. Stewart's evidence at trial is consistent with the conduct of the investigation as a whole. So Allergan is added in after the investigation has begun, and after it's added in, the CMA did not issue a single Section 26 notice to Allergan. So it did not ask any questions in the exercise of its power to ask questions or seeking documents. Nor did it ask to interview a single individual within Allergan. So nobody from Allergan was asked by the CMA to come and speak to them, to explain what they understood or what they knew. Allergan's role, or let me put it this way, the CMA had no interest in what Allergan knew or did or didn't know or didn't do. Allergan's role in the investigation was as a large international global parent company, and their role in the analysis in relation to the infringements comes at the point of penalty. And again, I'm going to return to this, but I do say that again this goes to proportionality, and it goes to the needs for specific deterrence. The CMA at no point in the investigation thought it was worthwhile calling anyone from Allergan in to ask them any questions. They are there, if I can put it this way, for the purposes of Part 10, not for the purposes of Parts 1 through 9 of the decision, which deal with the infringements. Well, I'm not going to turn up the judgment because of time. I was going to turn up my notice of appeal to make perhaps a rather glib, but I hope nonetheless important point. At the reference supplemental bundle tab 6 in volume 1, Allergan's submissions on penalties start at page 260. They finish at page 288. So there were just shy of 30 pages of pleaded case in relation to penalty filed by Allergan, going through each and every step systematically of the process, setting out its position. As you've heard from Ms. Ford and Mr. Palmer, there are 2 paragraphs of the judgment that address penalties on a completely omnibus level by reference to all of the appellants together. There's no differentiation, there's no separation of the analysis, there's no discussion at all, as you know, of stage 4 and the uplift. That simply doesn't appear in the judgment. And so we do say that the tribunal's reasoning is wholly inadequate. It's a failure to exercise its obligation to roll up its sleeve and assess the penalty ab initio. And that leads on to the first plank of my submissions, which is simply the tribunal just hasn't exercised its jurisdiction in relation to penalty. It's not dealt with the points set out in the NOA. That puts Allergan in a peculiarly disadvantageous position, because there is obviously no way in which I can develop in detail with you all of the grounds that formed the part of the original NOA. This is an appeal court, and I'm limited in terms of time, nor has this court, of course, heard the evidence. You can get a flavour of that at best. And against that backdrop, my primary submission is that if I can persuade you in the 20 minutes, half an hour that I have, that no fine should be imposed, or it should be very heavily reduced, you should proceed on that basis. But if I'm not able to persuade you of that, the judgment cannot stand.
Then the necessary consequence of that would be remission.
The necessary consequence of that must be that either the question of penalty is remitted to the CMA with guidance from the tribunal in light of what you've heard, if there are points that you find particularly persuasive or significant.
From this court.
Sorry, from this court, my apologies. Or remitted to the tribunal to have these matters determined. But what the court can't do, in my respectful submission, is uphold, in my client's case, a £75 million fine in circumstances where the appeal hasn't been dealt with below, and this is an appeal court, and my opportunity to canvass the points.
There's a common theme between all of the appellants on this, which is that you put in submissions which the CAT didn't address.
Yes.
And I wonder if it might be helpful to us just simply have an iteration or a list of submissions that you say you made which weren't addressed, not addressing the merits of them, points you say you put before the CAT which are not addressed in the CAT judgment. I mean, that might
we
be
can
quite
certainly
helpful.
do that.
It literally wouldn't need to be more than a couple of sides. Just an identification. This was the issue, either addressed or not addressed. If addressed, in which paragraph?
Yes, we can certainly do that, my lord. You, I think, see the force of the point that there is a
But you're making the
relationship
same
between
point.
the breadth of the submissions that were
Yes.
made and the substance. And coming back to your lordship's question this morning, which is why can't the tribunal say, well, actually, I find the decision unimpeachable, and that's absolutely fine. I mean, if that were right, then the tribunal could, of course, do that in respect of
Everything.
any decision. We could have a one-page judgment from the CAT that says, well, we had a 6-week trial, we have a 1,000-page long decision, there are hundreds of pages of evidence and submissions, but actually, rather than going through it all, we're just going to say that in the round,
All
we
sorts
find the
of
decision to
ingenious
be.
arguments were raised by counsel on both sides, but at the end of the day, we just think that CMA was right about everything. Full stop.
And as Ms. Ford pointed out, when it comes to penalty, there's a further problem, which is that the tribunal hasn't actually exercised its jurisdiction. It's applied the wrong test, it's treated it as a JR, and it said we don't find any material legal error. Well, that's a judicial review standard. It's not the exercise for the tribunal. So, my lord, I hope that.
Just from the list, a couple of sides.
Just a couple of signs, just identification. I think we'd like a document from everybody. Just like literally, it probably is no more than a couple of sides. This is the heading of the point we made. This is where we find it. This is what the CAT said about it or did not say about it. It would be no more than that, because
Yes.
the ground that you're all making is really more failure to address as a ground of appeal, as a point of law. And that may or may not be right, but if we weren't trying to measure that, whether or not we think the CAT did a proper job in addressing the CMA points, then it would be helpful to actually have that in short form, because we don't have time to go through
No, of course.
everything at this point, and nobody has.
And my lord, obviously there'll be two categories of failure to address. There'll be failure to address at all, and there'll be it's addressed in 4 sentences in this paragraph.
Well, that may be. We don't want. We don't want. Yes, no. I'm not going to prevent you doing that. We don't want submissions.
No, indeed.
We want an identification. Now, in terms of timing of this, it may be something which, well, it may be too tight to do it by the end of the hearing. We may need to just save the point and deal with it in writing afterwards. I mean, CMA may have views on this, but I think from our perspective, given that it's a common theme,
Yes.
we would like to understand with a bit more precision how it all pulls together. Because there may be a cumulative impact. It may not just be one. And if we decided that there were points common to all 4 which weren't addressed, or there were 27 points raised by the 4 of you which weren't addressed, that may be something that would be of assistance to us to know.
That makes perfect sense to me, my lord. Might I suggest this, which is that the parties liaise between them and come up with a timetable. I have no idea what everybody else's obligations are on Friday.
I mean, I don't
So
think
promising
it's
Friday
realistic
would
to
be
say
bad.
do it overnight and then give it to the CMA and ask them to respond tomorrow. It's a discrete point. It's not an unimportant point. We don't want to gloss over it. We need to understand the substance of it. If you will, talk and come back to us.
Yeah.
Grateful.
Is this just on the penalty points? Or is what,
Yes.
what the court's
Just
asking?
on-
It's,
just
it's,
on the-
it's really your failure to address or failure to address adequately. I mean, I think that probably encompasses a multitude of arguments, but that's, I think, what it boils down to.
So as my lord says, we've had really a common theme from all 3 of you.
Well, I'm very grateful for that. Very helpful suggestion. We'll work together to do what we can. That leads me on to my second point. I'm going to deal with this very briefly, which is intention and negligence. As I've already made the submission, the factual position in relation to Allergan's intention or negligence is relevant for 2 purposes. Firstly, whether or not a penalty can be imposed at all. Secondly, proportionality. As regards whether or not a penalty can be imposed at all, I'm going to direct you to my skeleton argument in the core bundle, tab 10, page 235, paragraphs 23 to 25. I'm not going to develop that point because I'm mindful of the time, but to put it really briefly in a nutshell, in substance, Allergan is subject to a bespoke fine that only applies to it. And if we could go to, in the core bundle, page 1660 and table 10.1, we'll see that. So at the top there, 10 milligram pricing abuse, Allergan and Accord UK jointly and severally liable. Yes, 74.3 million due to Accord UK statutory cap of 28.4 million applied to periods which it's solely liable. Allergan will be solely liable for the 74.3, and the only justification for that 74.3 is by reference to Allergan. And so the submission, and you have it in writing, and I'm not going to develop it any further, is that if you are imposing a penalty which you are justifying exclusively by reference to one company and it's going to be paid solely by that one company, then you need to consider the question of intention and negligence as regards that company. You have it in writing, my lords. I'm not going to develop that any further.
Sorry, so you're disagreeing there with the proposition that you have intention at the undertaking level is sufficient.
So the position is that if you are imposing a penalty at the level of the undertaking, then intention and negligence is addressed at the level of the undertaking. If, however, you decide, and the decision does it at a certain point, there's a fork in the road, it says now we're going to think about the penalty as it applies specifically to Allergan. It's £74.3 million, it's justified by reference to Allergan. Allergan's size, I'm going to come on and address you on this in a moment, Allergan's size, Allergan's turnover, and so on and so forth. At that point, where you are imposing a bespoke penalty, in my submission, there needs to be a connection between intentional negligence and the imposition of a penalty, because you have done, if you're addressing it solely at the level of undertaking, then it's perfectly proper, perfectly normal to deal with intentional negligence at the level of undertaking. But where the approach taken in this case is followed, then that requires you to go back and consider intention and negligence as regards the company. And so that's my first submission. You have it in writing. I also, as you know, rely on a very similar submission. All of these points come back in when it comes to the uplift. And so if I can put it this way, I rely on these points and the factual backdrop for both those purposes. Just turning briefly back to the uplift, Ms Ford showed it to you in the decision, so I won't take you to it again, but it's from, I think, £6.7 million to 73.4 at that point. So it's 1,000% uplift. Mr Palmer told you that a 400% uplift was whopping yesterday. I'm not quite sure what kind of rhetorical competition I should engage in, so I'll simply say that it's unprecedented in the sense that...
Bigly.
It's bigly. It's very, very bigly. And being as bigly as it is, it requires proper justification. It's unusual. Let me put it that way. I'll pitch it low. It's an unusual uplift. And that would warrant, in my submission, unusual facts, because it is a very, very substantial change in the scale of the fine at a point at which we've already been through seriousness, we've been through general deterrence, we've been through turnover, we've been through duration. Then you ask yourself, not to deter anyone else in the market, how big should this penalty be to make sure this company doesn't do this again? The answer in Allergan's case is 1,000% uplift. And in my submission, that can't be justified on the facts of this case. So just to crystallise those facts again, firstly, what I've told you about the investigation. Nobody at Allergan's interviewed. Section 26, requests not sent, not challenged at trial, but nobody at Allergan knew or should have known about the infringement. And thirdly, Allergan doesn't sell generic pharmaceuticals anymore. So when asking the question, what is necessary to deter Allergan from committing this infringement again, it has divested itself entirely, globally, of its generic pharmaceutical business. And against that backdrop, in my submission, the uplift cannot possibly be justified on grounds of specific deterrence to deter Allergan from doing this again.
When was the disposal of the entire generic business? Not on the sale to Teva later?
Yes, it is. So the sale to Teva is, and actually then what happens is, for various competitional reasons, there's a split, and so bits of the company go in different directions for antitrust reasons. But within, it's a really important point, Mel, within less than 2 months of Allergan's subsidiary buying this subsidiary, it has already sold the entirety of its generics business. And in fact, if you look at the way it's reporting it as discontinued. Mr. Stewart gives evidence on this. It's arm's length, it's sold to Teva, we're just managing it until Teva can take it over at that point.
So this, of the 9 months, 7 months, it's just managing on behalf of Teva until Teva take over.
Precisely so. So there's in fact a window right at the end where it goes into a whole separate box and Allergan's not allowed to know anything about it. And that's the point in respect to which we had an argument about whether it could be liable for an infringement at all. CMA said yes. Tribunal said no, that can't possibly be right.
This is a whole separate
It's a whole separate. You're legally precluded from giving any directions to it. But in the window before that, Mr. Stewart's evidence and his cross-examination is very clear on this, that it is, the generics business is sold very, very shortly after the purchase by the UK subsidiary of Auden.
Can I just ask in terms of sections 36 and 37, it's probably oversimplistic, but you start by looking at the intention of the undertaking and you impose fines by reference to the undertaking, but at some point you have to move from the general to the specific. So if you're trying to impose a deterrent, you could have a small company that takes over the group in 1 day before the end of the infringement, and the deterrent might have resulted in a huge uplift given the vast scale of the conglomerate who sold the company to the small company. And for the new owner, the last person, to have a huge uplift may be beyond its ability to pay. So you've got to somehow, even if you start with an analysis looking at the undertaking, you've got to segregate and allocate to individuals for the purpose of penalties at some point. And it's at that stage you're really just looking at how do you do this proportionately as between the various owners at various points in time.
Yes.
So if your global point is there should be 100 million fine, you allocate it on a proportionate basis to the various controllers of the undertaking over time. And is that really what this is about? Well, it doesn't quite easily fit into the steps in the guidance.
So, my lord, I think the way to think about it is that when one gets to step 4, 2 things happen. Firstly, is it necessary? Question. Presumption not being that it is, but is it necessary to impose an uplift for the purposes of specific deterrence, and then step back, look at the proportionality of it in the round? And you're right, there comes a point at which, in some cases, not in all, sometimes penalties are imposed at the level of undertaking, and other occasions they're imposed at the level of the individual companies within the undertaking. But the question becomes, looking at this case in the round, is the penalty imposed on Allergan
on the company that is being fined?
Yes, in this context.
As part and parcel of the undertaking over time?
Yes, precisely so. So in this context, Allergan solely liable for 74.3 million, which has obviously now been reduced because of the whole separate period, and solely liable for 34.8 million, also reduced because of the whole separate period. But you're asking yourself the question, is this penalty, A, sufficient to deter, B, proportionate looking at it in the round? And this is no plea at all for anybody else's penalties to be increased, of course, but it is a peculiar feature of this case that Allergan is liable for nearly a third of the total penalty in respect of a 9-month period when it appears to be agreed that it didn't know anything about the infringement. Or it certainly, let me lowball that in case I'm pitching it too high. It certainly wasn't contested at trial, and I don't think it's contested from my learned forensic argument, not the CMA's case, let's go that way.
Just so we've got this straight, can you just show us the determination in the decision and how that breaks up? Because like in the European Commission, so that the addressees, these are the addressees, this is for what they're liable.
Yeah, so my table 10.1, which I think should be on the screen, is where you get the different agreements and the liability attaching to them and the different individual companies.
Is that the only place?
Is there something like you get in a European Commission decision where you've got at the end of the decision? I don't think you always see that in a CMA decision. A formal dispositif or a determination.
I will be directed to the particular page possibly by somebody. As I say, one of the complexities, the easy way to think about Allergan's penalties, if this is an easy way to think about it at all, is roughly speaking you multiply them by 0.66 to get the new penalties when you take off the whole separate. So that's sort of it's a very ballpark way of thinking about it, but I hope in terms of being broadly helpful. Yeah, so I'm being pointed very helpfully by it's forward to page 1099. Sorry, 1747, 1099.
Yeah, it's bundle 5, isn't it? I've just turned that up. Yeah.
Sorry,
1747 of the bundle.
Under payment of claims.
Payment of penalties.
That's
So
down the page.
Can you just drop down the page, please?
and it says the entities to which this decision is addressed. Where is the actual formal addressing?
That's right at the start. That's paragraph 1, I think. I'm looking for the CMA, but I think it's literally paragraph 1.1 of the decision.
Page
655 of the bundle for your
Presumably
note.
if we go on to the next page, the pages then move on to... So there's no further explanation beyond that?
No, there is one, because in the course of the reasoning in respect to the decision, the CMA justifies why it is that it's arrived at these figures.
Yeah.
And so that's the next point I really need to address you on. Is how did the CMA get to this point?
Can I just, before you move on, you talk about Allergan being separately identified for this purpose, but that arises only as a result of the statutory cap. The penalties imposed upon Allergan and Accord UK. That's what the table 10.1 says.
Well, yes and no, my lord. I don't think that's quite right, because it's right that Allergan is solely liable because of the statutory cap, but when one comes to the reasoning in respect of step 4, that reasoning is in respect of Allergan. So the question that's being asked is, what is the global turnover of Allergan? What is the profit that has been made by Allergan? So I think it's not quite as straightforward as that, my lord. The rationale for the decision is by reference to Allergan. So if we could turn up page 10, paragraph 10.272, which is at page 1711 of the core bundle. It's 272. I take you to this because I don't doubt that my learned friends would like me to. Doubtless you'll hear the submission that the penalty at step 3 represents a small proportion of Allergan's global turnover and or profit, and that is true. But the CMA's approach is to look only at the size of the turnover and ignore the context in which it is made. And critically, the vast majority of that turnover is in other jurisdictions, and in many of those jurisdictions, excessive pricing is not a competition or infringement at all. So it's not a competition or infringement in America or in Australia, for example. And what the CMA has done, if I can put it this way, is the logic goes no further than to say, you are big, therefore you won't feel the pain enough, therefore we are going to very significantly increase the penalty. But my submission is that size alone is not enough, because the turnover needs to be rationally connected to the infringement. And there's strong authority for that. Rather than turn it, well, I'll take you to it in the skeleton argument. If I can ask you to go to paragraph 37.3 of my responsive skeleton argument, which you'll find at the core bundle, tab 10, page 240.
We're being told
240. So, in
we're being
paragraph
told there's no
37.
page on the electronic.
Page 240 is in the core bundle, page 240. 240. Thank you. And scroll down to paragraph 37.3. This is the Keir Group, one of the early tribunal authorities on penalties, and the point that's being made here is a rather obvious one. You can't just look at the size of the turnover, you have to ask, is it rationally connected to the infringement? And you'll see that in the submission that was put and accepted in that context by Mr. Unterhanther, I think, for the OFT. The CMA has treated this in a very mechanical way in my submission, particularly in circumstances where Allergan doesn't sell this kind of product. Another significant authority in the European context on this point, and I will turn this one up, it's Deutsche Telekom, it's in the authorities bundle at tab 3, sorry, volume 3, tab 41, page 1138. Hopefully it should be on the page. If we can have scroll down to paragraph 520. Just for context, this is a case that raised a number of points, but also raised the question of penalty, and in particular the imposition of an additional penalty on the parent company. And the core of the court's reasoning is that simply identifying the size of turnover without more is not sufficient to justify an uplift on a parent company. You have to look at the individual circumstances to warrant such an uplift. I won't read it to you, Miles, I'll let you read it. So Miles, that's the thrust of my submission. I don't think I need to elaborate very much on that paragraph. Turnover, of course, is something that the CMA is entitled to take into regard by reference to its fining guidance, but it's not a mechanical process of simply saying, you are large, therefore we are going to impose an unprecedented uplift in respect of this company in circumstances where, in the individual features and the individual facts pertinent to Allergan point strongly in the opposite direction. So that's the first limit of reasoning. The second points to Allergan's alleged profit from the infringement. So if we go back to the core bundle, tab 23, page 1665. This is something Mr. Palmer showed you earlier. You probably even have the figure in mind if we can scroll down. The 10 milligram agreement, you see it there. Keep going. Yes, we see it there, £37.9 million. Now that has to be reduced as regards Allergan, who are about £25 million, because Allergan's not liable for part of that period at all. So on the CMA's case, the unlawful profit is in the region of £25 million. But the penalty imposed on Allergan alone, in respect of the excessive pricing infringement only, when reduced, is 50 million. So it's double that figure. And then on top of that, we get another £25 million in respect to the 10 milligram agreement. So we have a situation where we have total global fines that are 3 times that number. And just for your note, of course, there's an uplift in relation to the 10 milligram agreement as well. I'm not going to address you on it in detail, but there's a 100% uplift there too. So we get 1,000% on the pricing, 100% on the 10 milligram agreement. 2 more points briefly that surface in my learned friend's skeleton argument. First is the seriousness of the infringement. 2 points on that. Firstly, this is double counting, because seriousness of the infringement is the first question one asks when establishing a penalty at stage 1. The CMA's selected the highest starting point of 30%. We don't bring it back in to the analysis at this point to justify the uplift. Secondly, it must be seriousness vis-a-vis Allergan, not in the abstract. It has to be on the facts of the case by reference to this uplift for specific deterrence. And you have my submission, that couldn't possibly be justified. The second is that this had an impact on the budget of the NHS. Now, with respect, penalties in competition law cannot be higher because the purchaser is a public authority. However fondly we all regard that public authority, that is a totally unprincipled proposition to rely upon. It must be the same whether or not the purchaser happens to be the NHS. Finally, just very briefly, I don't think I need to develop this any further, but just to touch on the point canvassed in the court yesterday, that the penalty on the earlier period might be higher because there's still an effect during the Intas period later. That would certainly be a novel approach to the fining of a company in relation to a period when it was not infringing. And remember, the starting point for all penalties is what's the time period as a multiplier. Secondly, that novel approach of increasing the penalty for some kind of umbrella period finds no expression at all, as far as I could see, in the penalty guidance. Of course, both the CMA and the CAT are bound to at least have regards of that guidance. And thirdly, this isn't a period of time in respect of which Allergan is A, able to exercise any control over the relevant subsidiary, or B, making any profits from sales. It's sold the business to Teva. It's in fact been through 2 hands by the time we get to the Intas period. So it's a little odd with respect to suggest that Allergan might be fined or have its fine justified or uplifted by reference to different periods in respect of which different companies take responsibility. So we do say that this is not the CMA's case, the decision as well, but also not a principle. Sorry, Marlon.
That might be thought to be a warning shot at Mr. Palmer, Mr. Johnson, because otherwise you get to a situation potentially where there's a sort of black hole in which nobody has to pay
feels.
My lord, if there's no infringement, there's no problem with having a black hole.
Well, and that I understand, but
And then Mr. Palmer has his submissions, which
what
I
about
don't.
the overhang period when the effect of the previous infringement is that prices remain high in the as it were the final period? Is there no basis for anybody paying a penalty for that?
If there's a period of time in which there's no infringement, then there's no basis for imposing a penalty on anyone. No. If there's a period of time when there is
Why?
infringement, why?
Why? Because if I run you over and you then suffer an evolving catastrophic injury which goes on for years, it gets worse and worse and worse, aren't I liable for the lot? Even though my tortious act finished a year or 2 years ago.
Well, there's two answers to that, my lord. The first is to say that is not how competition or damages penalties are calculated. So competition or penalties are calculated by reference to the period of the infringement, and that is a core function. It goes right in as the multiplier at the beginning of the process. Secondly, it would be.
You say that, I'm not certain that's right.
Why is that? Well, certainly that. Okay, let me put it this way. On the methodology adopted by the CMA, that is the approach that is taken, which is that time.
It may come in at some stage or other. The impact, generally, of the abuse. It formally finished on day one, but it had adverse effects on the market for the next year, 2 years. Can that not be taken into account at some stage?
Well, no, because a party cannot be penalised for consequences that are beyond its gift or ability to influence. This is in some ways, my lord, very similar to the hold separate period. This was the argument run by the CMA in relation to the hold separate period. They said, well, just because you're precluded from telling your subsidiaries what to do in that black box, you've sort of set the trajectory and the prices are maintained at that level in the black box and you take liability for it. And the tribunal absolutely rightly said, no, you cannot impose liability. There's no finding of infringement, you can't impose liability in respect of.
But there is a finding of infringement from years 1 to 9, which then continued continued into turn 10. There was an infringement to which this is causally connected. So on this hypothesis.
On this hypothesis, so in a period of time, if there is still an infringement, then of course the liability goes to the company which is in the hold separate period, and then it goes to Teva, and then it goes to Intas. If you find against Mr. Palmer that there is an infringement, then there's no problem here at all, because you then decide what is a proportionate penalty to impose on Mr. Palmer, and I don't advocate for that for a moment, of course, my lord. But as regards the suggestion that the penalty might be greater in respect of an earlier period because companies in an earlier period are liable for the conduct of companies in a later period.
No, the undertaking is.
But my client is not part of the undertaking.
Well, I understand. This is one of the conundrums in this whole question of we keep on, we get sucked into analysis of what is it we're finding. But anyway, yes. Okay.
So well, let me pitch it here, and then I need to move on. And I promise to be finished within 3 or 4 minutes by 1 o'clock, which is that would be an entirely novel departure in terms of the methodology of imposing penalties for this court to do that. Firstly, secondly, in my submission, it would be an unprincipled departure, and it would blow a hole in the way all of this works, because then we'd have these oleaginous fines that apply across all kinds of periods, before and after. It's already complicated enough in circumstances where Ms. Ford's client is responsible for something done by the undertaking that it purchased, but now we're talking about umbrella. And of course, umbrella might come into the context of damages. We see that's a completely separate question. We're all very familiar with this in competition law damages, that there's an umbrella period. It's never been a part of the law as regards penalties. And so, my lord, my earnest submission to you is that we should steer.
You can persuade us that it's not principled. The fact that it's novel will not deter us if it's principled.
It would also be. Well, the novelty is twofold. Firstly, it's not part of the finding guidance of the law. Secondly, it's not the CMA's case.
So if we go.
So what we'd be doing is we'd then be reading back into the decision further reasons that weren't in the decision in circumstances where
we'll see what the CMA says. It may become a non-issue.
Well, so you say if we did this, we'd be bigly wrong.
I would say it would be a bigly mistake, my lord, and it might be a troubling one for all of us. Well, that leads me very briefly on to my final submission in relation to proportionality, stepping back, looking at things in the round. The headline figures in my submission, firstly, are plainly disproportionate. It cannot possibly be proportionate to impose a penalty on Allergan of around £50 million for excessive pricing, uplift it for £76 million for the 3 infringements for a 9.5-month period in relation to a 10-year infringement, where that works out at ballpark about a third of the total penalties. Something has gone awry here. Part of the guidance is to step back and look at it in the round. And in my respectful submission, the CMA has failed to do that. And the tribunal, to the extent it considered this point at all, and in my submission it didn't, has also failed to do that. Second, if you're against me on the point that I addressed you briefly on in intention and negligence, everything comes back into the analysis here. All of the evidence, the way the CMA tested that evidence, Allergan is required to pay an enormous fine in circumstances where the CMA elected not to put in cross-examination that anybody within Allergan knew or should have known or could have known about the infringement. So one is forced to ask why. Why is Allergan bearing such a remarkable share of the penalties? And the only answer is because it's big. And on the CMA's case, it has the lowest level of culpability of any party in the investigation, but it's a large company, so it should pay a massive penalty. Third, finally, I endorse everything that the others have said in relation to imposing concurrent penalties for closely connected infringements. In Allergan's case, 10 milligram agreement, 10 milligram pricing, 20 milligram pricing, 10 milligram agreement. Well, that additional, roughly now, £23.5 million fine is an important part of the picture when one comes to proportionality, when one steps back and says, is this fine justified in a round? In my submission, it isn't. It doesn't make sense. It's contrary, in fact, to common sense, and it should be set aside. I'm very grateful for your indulgence in letting me go past 1 o'clock into Mr. Holmes as well.
Anything else? No. Thank you very much.
I'm grateful.
All rise in favour.
Yes, 2 o'clock.